That series might have hearing criminal appeal, your lordship might be remembering, might have. After 2-3 times, your lordship also have gone through the records, might have. So may I pray, might have, can it be taken prior to other after the motion matters, might?
It will not be possible today because the bench will have to rise early.
That's why I've seen my at 3 your lordship will write.
They have to rise because of a single bench.
Let us start.
And no, there is another problem because my esteemed brother may not be there after this. So therefore, we can't keep it part-time.
Oh, my lord is
Because there will be vacations. Lordship will not be available after that. So we don't want to keep it part-time. It will be a, what do you call, it will be taxing your time. We are here to hear some case or the other.
Madam, if you start, madam, it will continue if possible, madam. I am just because you have already gone only 5 witnesses you are to see. Madam.
No, we understand, but my esteemed brother has not gone through it, so we'll have to take time. In the process, it will be spending of your time.
Yeah, the problem is that when your lordship knows where this side your lordship gone the pressure to my juniors, madam.
No, we understand. All three of you can see a date after the opening. We fix it on that day. Preferably,
14 is a reopening.
Preferably in the week commencing 21st, if you can take it.
21st. 21st is Monday.
In commencing that week, either 22nd or 24th. Special bench,
22nd, my lord, Tuesday.
In the same.
Last 23. Because your lordship is tied with your lordship, madam. Other way, madam.
We understand. 22nd or 24th, whatever.
22nd, madam, this Tuesday.
22nd. These items are item number?
Item 23 to 27.
23 to 27. Also as a duly represented. As the bench should be rising at 3 o'clock, there is no likelihood of the argument concluded by then. So accordingly, let us change adjourn today. List on 22/7/2025.
My learned friend is also there, please.
As a record the presence, Mr. R.R. Kaushik, then the AVP is present.
Maybe not two additional affidavit. One is filed day before yesterday, and another is today itself. May I bring on record those additional affidavit? And in addition to that, one prayer item number 17. In the second half of I have some personal inconvenience. Can it be taken after the motion, my lord? Since I am praying for bail to the petitioners, my lord.
We'll upgrade it, but there are only 2 admission matters.
My lord. Obligation.
Lordship, I'm praying for listing this matter for motion, your lordship, tomorrow, your lordship.
Motion.
May I please, your lordship? I wish to mention for listing 2 criminal writ petition tomorrow, my lord.
This lordship, I'd like to mention a listing for interlocutory application in a connected criminal contempt manner, which is fixed tomorrow. But there's it can come up along with the criminal contempt manner.
Your lordship, for listing tomorrow, habeas corpus.
Much. I'd like to mention for a little correction, my lord. For a little correction, my lord. My lord, this may come on 27/6.
What correction?
So, motion report there.
27th, you are not listing any matter. 25th or 26th.
Yeah.
Item 1 for motion.
Yes.
Yeah, please, my lord, in this case, my lord, petitioner husband is a declared foreigner, my lord. He was declared foreigner by an expert opinion, my lord. My lord, on 12/12/2016, my lord, he was taken into custody and he was in detention camp, my lord. Thereafter, he was released on bail, my lord. My lord, on 23/5/2025, my lord, at midnight, my lord.
Ms. Verma, get the information tomorrow.
Yes, Lordship.
Where about?
Okay. Lordship, a copy of this may be given to me. We do not have a copy of the petition.
Give a copy right now. But Mr. A.H. Mark is already not counsel for the petitioner. As well as all the respondents are there. Oops. K. Fukan, CEC.
He has not made us party also, Lordship.
Huh?
We are not parties to the, only the superintendent of police is there. I'll get it, Lordship, from Nagaon.
Superintendent of Police Border Nagaon is a
Yes,
party
Lordship.
here, responsible for.
Give me 2 copies today, huh?
There are copy of the writ petition provided to Ms. A. Verma, and standing counsel for the FT matters, so as to enable her to obtain instructions as to the whereabouts of Raham Ali, R-A-H-A-M, Raham Ali. Was declared to be a foreigner by opinion dated 1/7/2010. Passed in page 19.
Copy, yeah, no copy of how much data copy it did even.
Okay, Thursday list on 25/6/2025.
Obliged.
Item 2,
Lordship, instructions tomorrow.
Day after
Day
tomorrow.
After tomorrow. Please give me the copy. Huh? Huh? नहीं, ठीक है ऐसे मैंने कुछ बाहर
Again, 26/6. 26. I made a
26.
mistake. Yes, item 2.
Lordship, this is the contested case, Lordship. The judgment and order dated, Lordship, 14/12/2023, page 83, Lordship.
Which page is the opinion?
Yes, Lordship, opinion is, Lordship, page 89,
59.
89, 89, 89.
Don't even know the page number.
It's number 89, Lordship.
Huh?
89. The last part, Lordship.
For the second time, we are telling you, don't even know your brief. You don't even know the page number. Your case is this W133, 3133.
3133.
Then you don't know your brief. We are so sorry to tell you. The opinion starts at page 83. You don't know even that.
In the last part, Lordship, in the.
Lordship is asking.
As the learned counsel for the petitioner does not know the page number of the of the opinion rendered or the matter stands adjourned today, list after the ensuing summer vacation on 14/7/2025.
Item 3,
May I please, your Lordship?
Yes.
Lordship, petitioner's father is arrested, under detention. 124.
We will call the records.
Lordship, already, instruction already received.
Huh?
The petitioners already filed petitioner father is detained without informing the ground, then petitioner file an habeas corpus petition. The respondent authorities, after that, respondent authorities submitted ex parte opinion in this habeas corpus petition.
Item 3.
3. And let's see the page number.
You want us to
Seven.
issue notice in the matter? You don't want us to issue a notice?
Lordship, kindly see the page number 70.
17.
17.
He has been served with the copy of the ex parte opinion now. Now he is challenging the opinion.
That's why we are issuing a notice.
This will go, Lordship. And opinion is of 23, Lordship. So let the records come. As it is already.
Under detention, Lordship, for the one from 1 month.
No, Lordship, let the records come. His whereabout, they filed a habeas corpus. Respondents already have told him where he is, Lordship. It's reflected in.
Here there is no prayer for the. Here there is no such prayer. You are asking for bail. We'll see that when the records come. It's opinion of 2023.
Sure.
We are not granting you bail right now.
Lordship, suffering some.
Pardon me.
The petitioner's father is suffering some disease. So, Lordship, if possible.
Okay. What disease?
Like heart disease, like so.
Where is the document?
So, Lordship, I have not able to open. If court permit, then I will file an application.
Okay. Heard. Your name?
S. Hussain.
N.
S. Hussain.
F. Hussain, learned
Yes.
counsel for the petitioner. S.
Yes, Lordship.
Hussain, learned counsel for the petitioner. All the respondents are there. Ex parte opinion dated 27/9/2023, page 53. Passed by so and so in FT case number so and so, police reference case number so and so, declaring the petitioner to be of for no force 25/3/1971 stream. No. It's not the petitioner.
Petitioner's father.
Petitioner's father is here, Lordship.
father of the petitioner. No, not the petitioner. Father of the petitioner, namely Muhammad Abdul Salam, MD, ABDUL, SALAM, declared to be a foreigner, postally at in Detention Ministry. Next one. The learned counsel for the petitioner has drawn the attention of the court to an order dated 5/6/2025, passed by this court in WP Criminal 20 of 2025, wherein the petitioner has been disclosed. The petitioner has been informed that his father is presently held at holding area located at Matia Gwalpara, pursuant to opinion dated 27/9/2023, referred above. Full stop. Next, under such circumstances, as the challenge is made by a person other than the proceedee, keeping the issue of maintainability open, issue notice returnable on 25/7/2025. Requisite extra copies of the writ petition be served on the learned CCC State and Department Council in course of the day. Next paragraph. The registry shall send a requisition for the records of concerned case by usual process as well as by email at the following email address of the learned tribunal. Next one, the prayer for bail shall be considered on receipt of tribunal's records. List on 25/7/2025. We are keeping the issue of maintainability open. Next time you make submissions on that.
Item 4.
May I please the lordships? Lord, the instruction was sought for me, Lord.
Yes.
Yes, Lordship. The petitioner is at 7th APBN Holding Center, Kokrajhar. Sharikula, I think, is the place.
Okay.
Lord, the detainee, my lord, was released on bail on, my lord, 5/6/2017, my lord. 21/4/2020, my lord. Thereafter, I am fulfilling all the conditions also, my lord.
Whether fulfilled or not, we'll
Where
have to
is-
get that report from the police.
My-
Lordship.
Where is that?
Lord, that report, if my lord respected senior friend can stop for from the police, my lord, can be disclosed, my lord. Otherwise, my lord, some stringent condition, my lord, can impose also, my lord.
Lordship.
No, we'll have to first get the information.
Yes,
My lord.
Actually,
Yes, yes.
last time when you made submissions, I did not,
Yes,
maybe
that-
it
that-
did not
that-
register on that day.
My lord, I have to submit fairly before, my lord, that paragraph is missing in my petition, my lord. So, my lord,
Okay.
my respected friend can obtain instruction.
No, but
Lord,
it'll
not
take again
only-
2 days' time. It'll take her time.
My-
Yes,
my-
not only that, Lordship, he had approached the High Court, his writ petition was dismissed.
That is correct.
That means he's a declared foreigner. He's not a,
No, it's okay, but once he says that he is complying with the order, but once Mr. Bhuya is saying that he is complying with the order,
Fine.
we'll get the information.
Lordship will fix it up after the vacation, Lordship.
Friday, my lord, can we make?
No, not Friday. Friday we have some difficulties. Because that is a day we have to close everything and then
Fine.
sign and then rise.
My lord.
That is a very taxing part.
My
We can't leave any file open on that day. That's the real difficulty. We'll have a try on Thursday if she can. Otherwise, we'll have to fix some other day. We
Right.
can't help it. But you'll have to give her one extra copy because she'll have to transmit it.
I have already served.
No, extra copy because she'll have to now transmit because
Yes,
of this order.
today itself, Milord,
Yeah.
and we have already served, Milord.
Uh,
The last stop present from the goes to and
all sides are duty represented. Yes. A. Verma and standing counsel for the FT matters has submitted that pursuant to order dated 26/2025, she has received telephonic instructions that
Husband, no?
the husband of the petitioner, namely, Mohammed Shaha, Shaha, Shaha Ali, was declared to be a foreigner by opinion dated 5/6/2017. Is presently being held at the holding center care of 7th AP Battalion at Saraikola, Kokrajhar. Next para. At this stage, the counsel for the petitioner has submitted that as per instructions received by him, the petitioner was released on bail by release order dated 21/4/2020 on certain conditions, and as per his instructions, the husband of the petitioner was complying with the conditions of grant of bail. Next para. Do you have a soft copy of the writ petition? It
Yes,
will be more better.
Soft copy I will furnish.
Ah.
Milord.
That will be better than hard
Well.
copy.
One hard copy also.
Yes, Milord. One hard copy and rest soft I will furnish. Milord.
Uh, Next para, in order to obtain, enable the learned standing counsel for the FT matter to obtain instructions as to whether the conditions of bail has been complied with by, where is that release order?
Milord, yes, the release order is at Milord, page 26, annex 3, Milord.
26.
Yes, Milord.
Is to be obtained from the officer in charge of Dholaigaon Police Station under the jurisdiction of Superintendent of Police Border Chirang, Kajilgaon. That a soft copy and a hard copy of the writ petition will be provided to the learned standing counsel for the FT matters, so to enable her to obtain instructions. Next para, the learned standing counsel for the FT matters is permitted to send a downloaded copy of this order to the it will be routed through the home or to the SP? To the home. Okay. To the home and political bureau department. Next para. List on Thursday, 26/6.
Milord, may I pray, Milord, that the family members may be allowed to meet.
Okay, we can give that. We just before that, no, before the list on so you say you permit the petitioner and one family member
One.
to meet the detained person named Mohammed Shah Ali, alias Shah Ali, at the holding area at 7th AP Battalion, Saraikola, district Kokrajhar, and to obtain signature of the detained person in the Wakalatama, which, comma, to be authenticated by the in charge of the said holding area. Just according on production of a certificate copy of this order for the in charge of the holding area. Comma, refutable, comma, shall permit the visitation right to the petitioner and one family member. Please transfer and so.
Item 5.
Maybe lordship. In info opinion page 62, my lord. Opinion 9 to 2024, my lord.
9 to 24
2024, yes.
is
Page 62. And the main,
there's some delay, you'll have to wait for bail.
my lord, kindly say the decision, my lord, 66. My lord, only the different two constancy, my name is recorded, my grandfather, two constancy, and my lord, 66, my lord, reason. My paternal grandfather initially, my lord, the constancy name, my lord, the Balibara, subsequently it is Rangavara. 66 page, my lord. Last part, reason.
But still there's a delay. We are not entertaining a bail application right now.
Only one year, my lord.
Copy of it only in 25.
No, that's okay, but there's a delay. We can just give you protection that not to be deported. But Mr. H. Ali, land counsel for the petitioner, all the respondents are there. Opinion dated 9/2/2024, page 62. Passed by so and so, in case number so and so, reference case number so and so. Declaring the petition to be a foreigner post 25/3/1971 stream. Notice returnable on 25/7/2021. Extra copies of the writ petition be served on the learned CGC State and Department of Caution in course of the day. Next para. The registry shall call for the records, relevant records from the concerned tribunal by usual process as well as through email to the following email address of the learned tribunal. Next para. The prayer for bail shall be considered on receipt of records. Next para. In the meantime, if the petitioner, namely
Jai, my lord.
Juhir,
Jai.
Juhir, Juhir, alias Muhammad Juhir, which I hear is given Muhammad Jahir, MD Jahir, Jahir, Ali, alias Juhir, is apprehended, comma, shall not be deported out of the country without order of the court. Next, list on 25/7.
Definition.
Item 6.
May I please, your lordship?
Yes.
Lordship, this matter may pass over for timing loss.
Lordship, opinion is dated 18/9/2019, Lordship. Lordship
We
may
issue
call
notice
the
giving the issue of material
Yes,
opens.
In the meantime, I may be protected, lordship,
No. 19, we can't protect you.
not to be deported, lordship.
No, in 19, we are not giving that protection also.
Lordship, call for the record.
have maintainability of protest.
Which was that page? 28.
28 is opinion, lordship.
But Mr.
A.K. Hazum.
A.K. Hajong, learned counsel for the petitioner. Page 28, opinion dated 18/9/2019. Passed by so-and-so in reference number so-and-so, R case number so-and-so. Which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next, in view of the inordinate delay in selling the opinion, keeping the issue of maintainability open, issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the learned state CGC Trade and Department of Counsel in course of the day. Expera. The registrar shall send the requisition for the records by usual process as well as by email to the concerned tribunal. Next, the prayer for bail shall be considered on receipt of records. List on 28/7/2025. Returnable on that day. Huh? Okay.
Item 7.
Opinion is on page number 82. Annexure 24.
82.
82.
Okay. Your name?
J.A. Sigdar.
J.A. Sigdar, I'm counsel for the petitioner. All the respondents are there. Page 82, opinion dated 5/2/2025. Passed by so in case number so-and-so, police reference number so-and-so. They were declaring the petition to be a foreigner post 25/3/1971. Notice extra copies in course of the day. Notice read only 4 weeks. Okay. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the possession date, bail of rupees 5,000, 10 days time. How much satisfaction of?
Dhubri. SP.
Dhubri, SP border Dhubri. Okay.
Item 8.
May I please, your lordship? Your lordship, the petitioner here is seeking protection so that he may go to the Supreme Court, assailing the order of this honorable court. The petitioner herein was declared foreigners by the Foreigners Tribunal, Ulubari, number 1, by the order dated 26/7/2017, page number 13. Thereafter, Annexure A of 1, page number 13. Thereafter, she preferred a writ petition, which
What
was.
is your prayer here?
So I may be able to go to Supreme Court assailing the order dated 11/10/18.
Oh, what actually you want from the court?
So
Walking stick,
I may
walking
not
stick,
be
a train
deported.
ticket, walking stick, a train ticket,
No, sir, your
or
lordship. No, I may not be deported.
No.
Lordship, FT opinion, holding her a foreigner.
Yes, your lordship.
High Court dismissed, review dismissed, Supreme Court also dismissed.
we have
Not yet filed.
we have legal aid committee. If somebody needs walking shoes or the tennis shoe type of shoes or walking stick, we will have to provide them.
So Lordship, judgment dated 11/10/18. He wants to now go to the
She was in
Supreme
the
Court.
wrong,
office.
when she was released from the detention after completion of the 2 years by the order.
No, the sad part is that you don't even know how to apply. If you wanted a leave from the court, you must also know the provision of law under which leave is granted.
Yes.
You don't even know that.
Yes, sir.
That is the sad part. We don't grant leave nowadays. So you don't even know the provision. That is the sad part. Even even if somebody must have come fresh from the law school, he would know it. There are a few students of law sitting here. You ask them, they will be, if they have touched Constitution of India, they will know how leave is to be granted by a High Court, how to approach the High Court, under which jurisdiction somebody has to approach the High Court. That is the sad part. Heard, Mr.
M.R. Sodhil.
M.R. Sodhil, learned counsel for the petitioner. All the respondents are there. Next para. By filing this, by filing this writ petition under Article 226 of the Constitution of India, The petitioner has prayed for order of prohibition to restrain the authorities to take the petitioner into custody or to deport him to Bangladesh till he approaches the Supreme Court of India to assail the order dated 11/10/2018 passed by this court. Next para. The learned standing counsel for the FT matters has submitted that by an opinion dated 26/7/2017, the petitioner has been declared to be a foreigner of, passed by Foreigners Tribunal number 1, Kamrup Rural, in GFT case number, this page
Page
13. So and so in so and so. Reference case number so and so. Declared the foreigner post 25/3/1971 stream. The said order was unsuccessfully challenged. Before this court, which was dismissed by order dated 15/4/2020. Oh, no, not 15/4/2020.
11/10/2018. Page 20.
28. Page 20. Order is to passed in WBC 86834 of 2017. Next paragraph. Thus, it is evident that the order dated 11/10/2018 passed by this court in WBC 6834 of 2017 had attained finality. Accordingly, this writ petition is misconceived. Accordingly, this writ petition stands dismissed in limine without issuance of notice on the respondents.
Deep levels.
Item 9.
Yeah.
Wait, please, Your Lordship. Lordship, impugn order page at 35, Your Lordship. Impugn order is at page number 35, Your Lordship. Lordship, order dated 21/5/2024, Your Lordship.
There's still some delay. You'll have to wait for some time for bail.
Not
Just delayed by a month. Your name?
Muhammad A. Rahman.
Mr. Mohammed A. Rahman, learned counsel for the petitioner. Of the respondents are there. Opinion dated 21/5/2024, page 35. Was by
Foreigners Tribunal, Bongaigaon number 2.
so and so in ENJN case number so and so. PS Jogi Gopa MTT case number so and so. They were declaring the petitioner to be a foreigner post 25/1971 stream. Notice extra copy in course of the day. Notice written on 28/7. Extra copy in course of the day. As per the registry shall send a requisition for the records by usual process as well as through the following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely so and so, is alias also, page 3. So and so, alias so and so is apprehended, she shall not be deported out of the country without order of the court.
Highly obliged.
This one, so and so, 26.
Item 10.
Opinion is at page number 102.
You take the form of order from
29, 30, 31.
Mr. J.A. Sigdev, Line Counsel for the petitioner. All the respondents are there. Page 102, opinion dated 28/3/2025. Passed by so and so in case number so and so. Police reference case number so and so. By declaring the petitioner to be a foreigner post 25/3/1971 stream. Tick mark, case numbers in the page 102. Issue notice returnable in 4 weeks. Extra copies in course of the day. Agency shall call for the relevant records from the concerned tribunal. Next paragraph. The prayer for bail is opposed by the Alliance Standing Counsel for the FT matters. Mr. Howard, considering the projection made in this petition. 10 days time to take bail of ₹5,000 to the satisfaction of SP border, Morigaon. Is it Morigaon? In the opinion, it is Nagaon. Page 102, it is Nagaon.
Lordship, it's Morigaon, Lordship. Page 102, Lordship.
102, receive a reference from Furnace Tribunal, Nagaon.
In our petition, nothing Nagaon does. Yes, the first line says Nagaon, Lordship. As a D voter.
We did not read the entire order. Just one line here and through, and we jump into conclusions.
My friend says if you go to Morigaon, records could take it. Records.
Reference to put some.
Reference to. Reference Nagaon. Reference is from Nagaon, Lordship. জাগিয়ে খুশিলে তো মরিগাঁওতে পড়িব Lordship, I think it should be Morigaon, Lordship.
Morigaon, okay.
Yes, Lordship.
SP border, Morigaon. But the name of the council is again interesting. Page 102.
For the opposite party, Zulfikar Ali Bhutto. Maybe reborn, your lordship.
We don't know, we can't.
Item 11.
It's after 4 weeks.
Opinion is at page number 73, annexure 17,
73.
73. Opinion dated 18/12/24.
Okay. Same order, the opinion will change. Page 73.
Hmm?
Opinion dated 18/12/24. Passed by so and so, case number so and so, police reference number so and so. SP border?
Dhubri.
Dhubri. Same order.
Item 12.
Yes.
Order is at page number 68, annexure number 18. Opinion is of dated 30/9/2024.
Same order. Page 68. Opinion. Dated 39/2024, passed by so and so, in case number so and so, reference number so and so. Declaring the petitioner to be a foreigner post 25/3/1971 stream. SP border,
Gwalpara.
Gwalpara. Same order.
Supplementary item for motion. Item 28.
Lordship, I have the instructions, Lordship. The petitioner is at holding center Matia.
Then we close the matter, permitting you to meet her and take Wakalatama.
Lordship.
Heard. Mr. I. Hussain, General Counsel for the petitioner. You write I. Hussain or M. I. Hussain?
MD, I would say.
MD, Mohammed MD, I. Hussain.
Matia.
The counsel for the petitioner. All the respondents are there. Next, by the case of the petitioner is that by an opinion dated 10/8/2022, asked by the learned member, Foreigners Tribunal Jorhat, in case number, dated page 11. It is also there in the last order, paragraph 2. Same. In so and so by so and so, the wife of the petitioner, namely, Rabia, Rabia Begum, alias Rubia, Rubia Begum, was declared to be a foreigner. First off, it is also submitted that on 26/5/2025, the police personnel from Golaghat Police Station had taken the wife of the petitioner into custody, and since then her whereabouts is not known. Next para. Pursuant to order dated 26/2025, the Learned Standing Counsel for the FT matters has submitted that as per telephonic instructions received by her, the said Rabia Begum, alias Rubia Begum, is currently lodged at Holdings area, Matia Gwalpara. Post op. Next para. Therefore, it appears that pursuant to the opinion dated 10/8/2022, referred above, the wife of the petitioner has been taken into custody as the said opinion has remained unchallenged. Stop. Accordingly, the detention of the wife of the petitioner cannot be held to be illegal. Next para. Be that as it may, having heard the learned counsel for the petitioner, the court is inclined to provide that on production of a certified copy of this order, the petitioner, namely page 3 spelling, Chaifaduddin Ahmed, Chayfattaddin Ahmed, along with one family member, shall be permitted by the in charge of the holding center, holding area. Ms. Verma, holding
Yes.
area or holding center?
Lordship, it is Matia Holding Center.
Holding center,
Yes, Lord.
Matia Gwalpara, to allow the petitioner and one family member to meet the detained person, namely Rabia Begum, alias Rubia Begum, and to take her signature in the Wakalatnama, which shall be authenticated by the in charge of the holding center. Well, this is a direction, these repetitions as this repetition for habeas corpus has served its purpose, and according to this repetition stands closed.
Lordship, if I may be granted some time, your lordship, to file the writ petition, your lordship.
We are permitting you.
Yes, your lordship. Till then, your lordship, she may not be pushed back, your lordship. Only.
Acha, okay. Okay. In order to enable the detained person to challenge the challenge the opinion, court is further inclined to provide that for a period of 1 month, a period of 30 days commencing from the date of the order, the said Rabia Begum, alias Rubia Begum, shall not be deported out of the country. Okay.
Much more.
30 days time is sufficient.
29.
Yes.
Petition.
Lordship, my brother is missing. He was on bail pursuant to the Supreme Court order. He was religiously following the bail condition. Last he appeared on 22nd May. And after that on 25th
Karim Ali is arrested. And since then, I don't know his whereabouts.
Okay. And Mr. D.K. Agarwal, counsel for the petitioner. All the respondents are there. Next one. The learned counsel for the petitioner has submitted that by an ex parte opinion dated 8/2/2005, Karim Ali, who is the brother of the petitioner, was declared to be a foreigner. He was declared to be a foreigner. So it is also submitted that pursuant to order dated 10/5/2019, passed by this court in WPC 1045 of 2018. Where is that order? High Court order?
Supreme Court order.
High Court order?
High Court order is at page 37. My SLP was also dismissed.
No, that bail order.
Bail order is at page 40. Supreme
What?
Court bail order.
No, you have said High Court order.
No,
Pursuant to High Court order.
no, pursuant to this honorable Supreme Court's order.
Come to your synopsis.
Dismiss recovered.
Subsequently, he was released on pursuant to the order dated passed by the honorable Supreme Court.
That was COVID order.
Yeah.
Held for that, no?
No, I have submitted.
That was.
Where you are writing Supreme Court?
At the end, Your Lordship. Subsequently, he was released on to 9/11/2019.
Okay, Supreme Court.
Supreme Court,
Okay,
Lordship,
okay.
that blanket order, Lordship.
Oh, acha.
Easy करा करो. अच्छे लोग अभी भी ठीक हो.
Pursuant to order passed by the Supreme Court of India in WPC number 1045/2018. The said Karim Ali was released on bail on 9/11/2019. So it is submitted that the brother of the petitioner was complying with the directions contained in the bail order. Next para. Accordingly, request the standing counsel for the active matters to obtain instructions through the home concerned officials of the Home and Political within bracket B department about the whereabouts of
instructions.
Karim Ali. Where is that opinion?
The tribunal opinion at page 29. IMDT.
इतना maintainability ऊपर जापो लगी हुई तो.
No, which spelling is right?
So it's a
You in your writ petition in your synopsis first line you write Rahim Ali. Somewhere you write Rohim Ali.
Korim Lordship petitioner.
so there is different variation.
Korim Ali.
Korim Abdul.
Then again there is Abdul Korim.
Karim Ali.
Which is the right spelling?
So yes, there are three variations of the same name. So that is the difficulty. So Karim Ali, Abdul Karim, and Karim Ali. So that is why it have used.
Lordship.
Whereabouts of Korim Ali, Korim, Korim Ali, alias Abdul Korim, Korim, alias Karim Ali, Karim Karim Ali, against whom ex parte opinion dated 8/2/2005 was passed by the learned illegal migrants within bracket determination bracket close tribunal, Borpeta. Next, which is the jurisdictional police station?
Borpeta.
Borpeta. Next, in the meanwhile, the learned standing counsel for the FT matters will also obtain instructions from the Women Political within bracket B department, from the officer in charge of Borpeta police station as to whether the said Karim Ali alias Abdul Karim alias Karim Ali was released on bail by order dated 9/11/2019, has been complying with the conditions on which bail was granted. Next list on Thursday, 26th.
Extra copy.
Extra copy. Soft copy and hard copy.
Yes,
both in course of the day. Just before that, you write, before list on so you write that the learned counsel for the petitioner shall provide a soft copy as well as a hard copy of the writ petition to the standing counsel for the FT matters, so enable her to obtain instructions.
Which one?
Puri. Yes. 30.
Lordship, here the petitioner is at Kokrajar Holding Center, Lordship. 7th APBM, Saraikula. Saraikula, Kokrajar.
Petitioner's husband.
Yeah.
Okay, here also you'll have to obtain that instruction whether he's complying with the order of the bail. You forgot to pass orders on the last occasion. At holding center, Gwalpara.
No, Lordship,
Kokrajar. Okay.
7th APBM,
Seventh APBM.
Saraikula,
Okay.
Kokrajar.
Okay.
Similar to item 4, Milo.
Mr. A.R. Here, the counsel for the petitioner. Okay, respondents are there.
The full instruction. Soft copy, you can take his email and.
Pursuant to order dated 26/2025, passed by this court, Ms. A. Verma and standing counsel for the FT matters has submitted that she has received verbal instructions that the husband of the petitioner, namely, Sohrab, Sohrab, Ali Paramanik, Pramanik, who was declared to be a foreigner post 1971 stream, wide opinion dated 11/11/2016, passed by the learned member, foreigners tribunal, Chirang, in case number that you'll find in case 17. Case number 17, and in the last order, paragraph 2.
430 instructions like it.
Is presently being held at the holding center at 7th AB Battalion, Saraikula, in the district of Kokrajar. Accordingly, court is inclined to provide that on production of a certified copy of this order, the in charge of the holding center, 7th AP Battalion, Saraikula, district Kokrajar, shall permit the petitioner, namely Malika Begum, Malika Begum, and one family member to meet her husband, named Sohrab Ali Paramanik, along with one family member to obtain signature in the Wakalatnama. Next para. The learned standing counsel for the next para. The learned standing counsel for the empty matter shall also obtain instructions from which police station?
Lord,
Chirang.
Haligaon, my lord, Haligaon police station.
Officer in charge of Dhaligaon police station as to whether the said Sohrab Ali Paramani is complying with the conditions of bail. By which order?
My lord, the release order is at page 32, annexure 3, my lord.
32.
17/1/2020, my lord.
Because a person to conditions as provided by release order dated 17/1/2020 passed by the Superintendent of Police, Border Chirang, Kazilgaon. Within bracket, annexure 3, page 32. To enable the learned standing counsel for the FT matters to obtain instructions. The learned counsel for the petitioner shall provide a soft copy as well as a hard copy of this writ petition in course of the day. Next one, list on 26.
Lord, Lord, we are also apprehending that during this time, you know, if they deport us, my
In
lord.
these 2 days, it will not happen.
My lord. My lord.
The instruction. is-
Obliged, my lord, highly obliged.
Item 31.
Made. My lord, we have filed, my lord, additional affidavit today, my lord. Then their lordship will find the order sheet we have annexed, my lord, the entire order sheet.
We don't have a
Except
copy of
few, my lord.
the affidavit. We don't have a copy.
Copy এটা দিতে, madam. Madam, copy এটা দিয়ে দিও।
হাত নাই উপরে তো দিব পিছনে আসবে হ্যাঁ
দিবে তো হোগা नहीं। Copy দিবে তো হোগা नहीं। From the additional affidavit, lordship will find page 64. Page 64, my lord, order dated
just a moment
6/5/2024.
just a moment
এটা দিয়েছে না। কপি এটা দিও। এটা দিব না এটা এক্সট্রা কপি আনবো লাগে তো। petition লাগে তো দিচ্ছি।
Learned counsel for the petitioner, all the respondents are there. Next para. As the entire order sheet has not been produced, comma, we put the petitioner to notice to explain the conduct of withholding documents from the court and to file an affidavit as to why the writ petition should not be dismissed in limine. Full stop. The notice is made returnable on 30/7/2025, list accordingly. The entire order sheet is not produced.
Yes, entire order sheet is not, some pages
Yes, sir,
are.
now, you see, if that is your instructions, we are issuing a notice
Yes.
why it should not be dismissed. File an affidavit.
Now, while obtaining the certificate, some of the pages are not.
I understand. I've been there where you are standing.
I will.
I have never received a certified copy which is not in serial order.
Now, while making Xerox, my lord, in the trial court, my lord, some of the pages are not. See. Now, my lord, only problem, my lord, next date is, my lord, 2/7/2024/25 for argument, my lord.
Do it.
Now-
Since there is no stay operating,
Yes.
this pendency of the writ petition shall not be a bar for the learned so-and-so tribunal to proceed with the matter.
Now, without, my lord, adducing the, my lord, further evidence and official evidence, it will be very
That
difficult.
missing photocopy,
Yes, that's true.
blame
that's
it.
true.
Blame it on that missing photocopy.
Yes, that's.
Then
That is, of course, the hours for, my lord, we have not verified at the
Next.
time of.
next, we request the learned standing counsel for the FT matters to transmit a copy of this order to the concerned tribunal, to the Home and Political B Department.
Obligation.
Item 13.
May-
Yes, Mr. Fukan.
In this case, lordship, LCR has received lordship.
We'll fix it after vacation for hearing.
Lordship.
You're on bail.
Lordship.
Heard Mr. R. Fukan, learned counsel for the petitioner. All the respondents are represent, give the names, so are present. Next, as records of the tribunal is received. The court is inclined to issue rule returnable forthwith without requiring fresh steps to be taken by the petitioner. Next, list the matter for hearing in the week commencing 28/7/2025.
Obligation.
Item 14 for admission.
Please, your lordship. We also LCR received lordship.
Yes.
Only thing that the petitioner is aged about now 82 years lordship. Bail, he's on bail lordship.
Is it bail? Okay, we
Lordship,
understand.
for down 1/10/2024.
But these 3 days will not be able to hear any
Lordship,
matter.
what a vacation.
Same. Mr. R. Fukan, learned counsel for the petitioner, all the respondents are there. As the records are received, same order. You should same order last. You also say The learned counsel for the petitioner further submits that as per instructions received by him, the petitioner is now 82 years of age. Accordingly, on the next date of listing, the learned counsel for the petitioner is granted liberty to make a mention for taking up the hearing out of turn.
Obliged.
Orders, item 15.
But the application is about restoration, my lord, we'd like to file our objections, my lord. My lord, what happened subsequently, certain development has also taken place in regard to the allotment issue, man. Everything I would like to bring on record, man.
Dismissed for default.
No, sir, no settlement of it.
Why it was dismissed?
My lord,
For
because of
non-prosecution,
non-prosecution.
and I have moved an application.
My lord,
present
order dated
Just a moment, one by one.
Yes.
Yes, Mr. Gwala.
I am Satish Sharma, I am representing the appeal.
Okay.
On 17th of February 2025, my rate appeal was dismissed for non-prosecution due to the non-appearance of none from the appellant. However, I filed the medical documents. My mother was suffering from cancer, and on 7th of May 2025, she had left to heavenly abode.
You still want to file an objection?
my lord, reason is that, my lord, the issue is about allotment, my lord. No doubt, my lord, this is not a bigger issue, but my lord, so far allotment is concerned, they have.
That is some merit. We'll hear on merit because once the council says that his mother is suffering from
There is no problem, there is no
and she is
issue.
expired.
Only thing that my so far the amount is concerned, but they have deposited, my
No,
lord.
that is something
That is in
come in
written.
the main
No problem.
case. Your name?
Sachit Sharma.
Sachit Sharma.
Yes, sir.
But Mr. Sachit Sharma, and counsel for the petitioner, also heard petitioners also heard Mr. S. Samariel, and standing counsel for the respondents. Next paragraph. The petitioners are the appellants in Writ Appeal 309 of 2024, which was dismissed for non-prosecution by order dated 17/2/2025. Next paragraph, the learned counsel for the petitioner has submitted that his mother was suffering from recurrent carcinoma of the ovary, carcinoma of the ovary, and in the meanwhile, on
7th of May.
7th of May 2025, she had expired, and it is because of her ailment that the learned counsel for the petitioner was unable to appear before the court when the matter was called on 17/2/2025. Next paragraph. Although the learned counsel for the respondents has objected to the prayer made, but considering the nature of prayer, nature of explanation tendered, the same is accepted as good and sufficient reason for the petitioners to remain unrepresented when the matter was called on 17/2/2025. So accordingly, the said order dated 17/2/2025 passed in WA 309 of 2024 stands recalled. And the connected WA 309 of 2024 is restored to file. Next paragraph. The registry shall list the said WA 39 of 309 of 2024 on
23rd or 22nd of July. 23rd of July, 20.
Okay, yes, Mr. Samaria,
No problem.
23/7/2025, first of. By which time objection, if any, in the appeal shall also be filed by the respondents.
Highly obliged.
Miscase disbursement. We'll take a short break and resume again. টমেটো বন্ধ করে দেবো, ঠান্ডা বেশি হয়ে গেছে।
Item 16 for orders.
My lord, before my learned friend begins, my lord, today I have some personal difficulty, my lord. My lord, may kindly hear it only immediately after opening of the vacations, my on the 15th of July.
Lordship, my senior is on legs, therefore if the council wants after vacation, then I would have prayed for time being.
When do you want? When do you want?
After vacation.
When?
After any date convenient to my lords.
Okay. What is the stage of the writ petition?
My lord, pleadings have been completed. Writ petition, my lord, it is pending. It has been adjourned twice because this appeal is pending, my lord. Because of this appeal,
This appeal is only against the interim order.
Against the interim order, my lord.
So we make it clear that the pendency of the appeal shall not be a bar.
My lord, please. My lord.
Because
My lord.
it's an interim order, it
My-
doesn't prevent the court from hearing the main matter.
My lord.
Okay, both sides are represented. Mr. R. Sharma and the senior counsel, assisted by Ms. P. Fukan, and counsel for the respondent. Some is that he has some personal difficulties today and therefore he prays for an adjournment. Stop the prayer is considered and allowed. Next paragraph. On the court query as to what is the present status of the
Writ petition number 735.
writ petition.
735 of 2025.
78.
No, I'm sorry, 738 of 20.
Status of WPC 738 of 2025. Both sides have submitted that. In the meanwhile, the pleadings are completed and the matter is ready for hearing. And full stop, it is also submitted that due to pendency of this appeal, the writ petition has not been taken up for hearing. Next paragraph. As this appeal is directed against the interim order passed by the learned against the dismissal of the interlocutory application by the learned single judge, the pendency of this appeal shall not be a bar for the hearing of the said WBC 738 of
2025.
2025.
And my lord, there's another analogous matter that is the more important matter, 6142 of 2024.
And the connected Writ petition.
6142.
being WSC, the WBC
42
6142
of 2024.
2024. Next paragraph, first. List on 17/7/2025.
Oblige, great.
Item 17.
May I please? My lord, in terms of the my lord, updated medical document, my lord, we have filed my lord additional affidavit. In the additional affidavit, lordship will find at page 108. He has been suffering from my lord, diabetes, my lord, type 2 category. Page 108, my lord. Additional affidavit.
In your writ petition, shows the best document you have to connect you to your projected parents.
Projected parents, my lord.
Which is the best document you have. Don't show us the voters list.
My lord. My lord, first, my lord, exhibit A, my lord, page 19, lordship will find. Page 19.
No, don't show us the voters list.
My lord.
Apart from voters list, do you have any other document to connect you to your projected parents?
Yes. My lord, lordship will find land document, my lord, job on the copy at page 49. Page 49, my lord.
Page 14. This is not an exhibited document.
No.
This is not exhibited document. Page 49, my lord. Lordship will find serial number 1, my lord, Mafezuddin Sheikh, father.
No, if it's not an exhibited document, we will not look into it.
Yes.
Which page is your sale deed?
Omelette. Sale deed my lord, page 64.
Page number?
Page 64, my lord, the operative portion of type copy, and vernacular, my lord, page 65.
But you see, even if you look at this Jamamandi, it's a document of 23/10/1996. And this sale deed is also 1/2/2012.
Yes.
So these are all post 25/3/1971 document.
But Javamundi, my lord, that was the property, my lord, inherited by the petitioner. From
No, but that land itself was settled to you in 1996.
Yes.
It's not a pre-25/3/1971 document.
Yes. That's true, that's true. Now, apart from that, my lord, his name appeared in the my lord, final NRC, and which has been, my lord, recently Honorable Apex Court has upheld, my lord. We have annexed the my lord, NRC copy also.
NRC is not yet finalized, Lordship.
Get notified,
Not yet.
not yet.
Now, since Supreme Court has cleared the my lord, NRC prepared by the my lord, respondent authorities. Now only my lord, notification is required.
But that's apart, but still till now, till the notification is not there.
Yes, yes, that
It
is
doesn't
true.
become an admissible document.
Yes. Now, my lord, in addition to that, Lordship has already seen the my lord, medical document, my lord, page 110, my lord, 110. There is another my lord, certificate, my lord, of course, my lord, medical report. We suggested that my lord, she is my lord, grade 1 LB diastolic dysfunctioning. Page 110, my lord, in the additional affidavit.
Additional affidavit.
Yes, my lord. And this gentleman is not, is it about 61 years? Page 110, my lord.
Diastolic dysfunction.
In the additional affidavit. my lord.
Diastolic dysfunction. MP diastolic function. Grade 1 MP diastolic.
Genorism, biorism.
Hero the photo. Outside.
Here.
Outside the sign.
Page 110, my lord, additional affidavit. Now, last line, my lord, impression, normal LB systolic function, grade 1 LB dystolic dysfunction. Now, 61 years, my lord, man, my lord, who is suffering from diabetes 2 category, my lord, as lordship we have already seen. Now, considering this, my lord, age and my lord, medical ground, my lord, he may be allowed to appear before the SP, and on his appearance, he may be allowed to go on bail, my lord. That must only, my lord. Diabetes 2.
Let us see your voters list of 1966 you are showing us.
Yes.
How do you connect yourself?
That voter list, my lord, 1966, lordship will find at page 19. Page 19, my lord. Mafez Sheikh, father of the petitioner, my lord.
Where is your written statement?
Written statement, lordship, at page 70, my lord.
70.
70.
Okay, next, voter list of 1970.
Yes. Next voter list, my lord, lordship will find at page, my lord, 21.
Mafe Sheikh.
Now, page, my lord, 38, lordship will find the petitioner's voter list along with her family members, my lord. Page 38, my lord.
No, after 1970, what is the next voter list?
After 1970, my lord.
1989.
1989, my lord, page 26. Property part, my lord, page 27. Her mother, Lal Bhanu, and petitioner, my lord, Lal Chan Mia. Now, two names indicated, one Lal Chan Mia and my lord, Pahar Ali. That is the, my lord,
Have you pleaded when your father expired?
No. Not latest.
It's not there.
No.
Evidence of person.
Order reflects. Page 101.
But Mr. Mandal, then there's a disconnect. There's no connectivity.
Now, since my lord, his my lord, name appeared in the voter list with his father, showing that Mapes.
Where is that voter list?
My lord, first lordship will find. Page my lord, 13. Page my lord, 32 first lordship and list. 32.
32.
32.
Your name is Pahar Ali Lalchan Ali.
My lord.
Your name is not there in page 32.
Yes. 32, not 32. My lord, 38, my lord. Sorry, my lord. 38.
8.
38. Maharali Mafes.
No, but here there is a name Lal Bhanu.
My lord.
Who is she?
She is the my lord mother.
She is the mother.
Mother.
Where is the voter list of father and mother together?
My lord, page 21, lordship will find. And so. Page 19. Mafes and full Banu.
But this is Lal Bhanu. It's
It-
not full Khatun.
Yes, full Khatun.
Full Khatun, then
Oh,
the
sorry,
husband's name is different. Mahizuddin.
Yes, it is my lord, aunt of the petitioner.
No. We are not concerned with aunt.
Yes. My lord, page 27. Lordship will find. My lord, father might have been expired, my lord. Then Lal Banu, mother, and my lord, petitioner Lal Chan Mia, petitioner. Page 27.
Connected person is Hanif, lordship, and Lalsan Mia, it is Mafis.
But this is a different village, Mandia Pathar.
Yes.
There's something wrong. You don't
Names-
find, we
names
don't find a
the-
match. You see, in your written statement at page 70, it starts, in the written statement, you say, paragraph 9, father of the second party was inhabitant of Phub Balikuri in Onke, and he shifted to Bordoloni, Mandia Pathar due to purchase of land.
My lord.
So if you have purchased land, how will the village change, shift from one place to village another?
Now in the my lord, Chor, my lord,
That
Chor-
document of land is not there.
now in the my lord, river eroded particularly my lord
No, we
area.
understand.
There is
We
a
are not
west
questioning
shifting
you
of
for that.
residence, my lord.
We are not questioning you for that. But if you have land,
Yes.
there's nothing to show that you had land and shifted.
Now, my lord, only my lord, my prayer. The man is my lord suffering from my lord diabetes 2 and my lord,
Okay,
heart problem.
But there must be something on merit also.
Now, that is there, my lord. Some discrepancy there in the voter list, lordship has already seen, my lord. We have no, my lord, objection on that. But considering the, my lord, medical report, my lord, medical ground, my lord, that must only, my lord. If, my lord, man is arrested, my lord, he will die on the spot because of his heart problem.
That we can't say how much life God has given to anyone. We
Yes,
can't
that
say.
that we have seen from the, my lord, medical report of the cardiologist department, my lord. So considering
For the
that
bench,
part
I can
only-
tell you that out of the bench sitting here, I am suffering from more difficulties than medical difficulties than my esteemed brother.
my lord, he will appear once in every week, my lord, before the SP
No,
concern,
but
my
in
lord.
merit, you don't have a case. You don't find any merit in your case. There's no connectivity.
Yes.
At least some document, if it can be shown, then we understand. Otherwise, on merit also, when we see the writ petition, you don't have a ground to challenge the impugn opinion.
Now, my lord, there are, my lord, two opinion. My lord, the NRC says I am a citizen of India.
No.
As lordship has
NRC
already-
would be subject to opinion that has been passed by the foreigners tribunal.
Yes.
NRC
Now,
may have declared
NRC
you.
is, my lord, prepared prior to the, my lord, NRC, my lord, the impugn order. Impugn order in the year 2022, NRC in the year 2019. Now, my lord, I am not submitting on merit, my lord, as on date, my lord. Considering the my lord
No, but
medical
we are
ground, my lord,
considering on merit also. That's why we are looking at the documents. We are trying to examine if you have any case, then we would have admitted it. But
now,
we're
if
not
my lord,
finding you.
if he is my lord arrested and detained in the my lord camp, my lord, before came to the detention camp, he would die because
That we
his
don't
heart
know.
problem.
That we don't know. Mr. Mandal, I have repeated this story so many times. I was ill. I went to a doctor. And the surprising news the doctor gave me that I don't have a heart. He checked up and did not find heart. So he was surprised how I'm surviving.
Only that must, my lord, considering the my lord medical ground, my lord.
When we are sitting here, at times it may come that by my order somebody would be hanged to death. So therefore, you don't take responsibility of that.
Only that must only. He will appear once in a week before the
But
SP
we don't
comes up,
have
my
a
lord.
case unless you show some connectivity which can clear a doubt.
Now, the my lord NRC, my lord, if your lordship kindly consider in the my lord IA, we have annexed the my lord NRC. Lordship will find at page my lord 23 in the IA. And page 24, my lord, the vernacular, lordship will find Lal Banu, mother, Pahar Ali, petitioner, Mofez Ali, and all.
Mr. Mandal,
My lord.
you are a good man. You see only the bright side of the sunny side of the morning. You are looking at page 24. It's the
24.
sunny side of the morning.
24. my lord.
We are accustomed to look at the dark side of the morning. Come to page 25, paragraph C.
25.
Paragraph C.
Paragraph C, my lord. Yes. Discovery at any point of time of a person being ineligible for inclusion in the ERC on the ground of being a declared foreigner post 1971 illegal so and so so and so so and so so and so. A person with a case pending foreigners tribunal, doubtful, descendant, and also as personality will be lead to the exclusion deletion from the NRC rule so and so so and so and issue so and so so and so so and so. That's true.
But that is the difference between a good man and a.
That's true. Now, my lord, that's true, my lord. That is always, my lord. Now, lordship will consider, my lord, it is a matter of a record. We cannot go beyond the records. Now, one, my lord, there is a two opinion. One, the NRC of the authority saying that I am a citizen of India, and foreigner tribunal say I am a foreigners of post in my lord, 1971. Now, which version will be, my lord, correct? That has to be decided by the, my lord, this authority, my lord. I am not saying, my lord, I am not objecting at this moment, my lord, but it has to be decided by this authority, my lord. Which one is correct? If, my lord, lordship is hold, my lord, this NRC is, my lord, valid for all purpose, then I succeed. If lordship kindly, my lord, hold that this is not correct position, then we'll go by the, my lord, opinion impugned by the tribunal, my lord.
Okay.
That your lordship will consider.
Examine and pass orders.
And, my lord,
What do you say?
my lord, one more submission, my lord.
Yes.
Page, my lord, 26, lordship will find. Page 26.
26 of IA or the writ petition?
IA, my lord.
IA. Yes.
Yes. Now, my lord, Supreme Court order, in an identical case, my lord, like the petitioner, my lord, lordship will find, it says, my lord, additional affidavit has been filed by on behalf of the petitioner to show that name of the petitioner is included in the final draft NRC, National Register of Citizenship. Delay condoned, issue notice. Until the further order, there will be a stay of the judgment and order dated so and so passed by the Guwahati High Court, so and so, so and so, so and so, it is petition, civil number so and so, also judgment and order dated, so and so, passed by the Land and Foreign Tribunal, Golpura, in so and so, so and so. Now, apex code also, note the NRC. Now, again, page 27, Lordship will find another identical order, like the petitioner, given by the Honorable Apex Court, page 27, my lord. Lordship got it. Page 27. Learned counsel appearing on behalf of the petitioner has informed us that his name has since been included in the NRC. This being the case, we set aside the impugned orders. It will be often for the learned counsel appearing on behalf of the State of Assam to verify this fact, and if found to be incorrect, back to us. Since petitioner is a similarly footed candidate, my lords, so his may be considered. My lord. And Lordship will ultimately decide, the issue will be decided, my lord, by this Honorable Court, whether he is a foreigner or, my lord, citizen of India. Now, considering, my lord, this, my lord, order taken note by the Honorable Apex Court, as well as the recent, my lord, Supreme Court order in the context of the NRC, since his name is included in the final NRC, my lord, let him stay, my lord, till, my lord, the decision taken by the respective authorities, my lord, considering the medical ground, my lord. That must be. There is a interim protection granted by this Honorable Court earlier also. A stay at home, my lord, it would be beneficiary to the state because the government exchequer would not be disturbed.
So worried
Yes.
about the government exchequer, Lordship.
Any condition, my lord, he will, my lord, avoid, my lord.
Link is missing, Dada.
There's another good thing about you. You come to page 110. You showed us this page.
110, my lord.
Yes, this is the page you showed us. Grade 1 LV diastolic dysfunction.
My lord.
Correct.
My lord.
Incidentally, come to the final opinion at page 109.
109. Yes. ECG report, my lord.
Yes.
Yes.
Final impression.
Yes.
No.
Normal sinus rhythm.
Yes.
Rightward axis.
Yes. Yes, my lord, we have searched in the, my lord, online.
That's okay, but ECG report, final opinion is there at page 109.
Yes. This is regarding ECG report. And
Next
my
is
lord,
also ECG.
page
There-
110, my lord.
Therefore, the ECG report, when the echocardiogram report was given,
Yes. It is same date, my lord.
correct, but the final opinion is by the doctor.
Yes,
You see, both the opinions are signed by the same doctor.
my lord.
One is a report when he finds the ECG, he finds for a specific purpose, he states that it's a diastolic dysfunction.
Yes.
But when entire report is seen, he gives the opinion that normal sinus rhythm.
That, my lord,
Right foot
my
axis.
limited, my lord, knowledge, you have no, my lord, medical knowledge.
No, I also have limited knowledge. I was just showing you the difference between a good person and a not so good person. Okay, we'll pass orders. Okay, I'm sorry, I did not hear you. Yes.
Lordship, my submission would be first, since my friend is relying on the NRC part, NRC is yet to be notified. So even if his name is there and he's a declared foreigner,
It is showing that the Supreme Court has dismissed it just because name was there in the NRC.
Lordship, it is just says that notice has been issued, delay condoned, but nothing
No,
on
next
merit.
page, next page.
It's
The
27.
opinion, final opinion was set aside
It's 27.
on the ground that NRC name is appeared. So why we should
But
not
Lordship,
consider
we
it?
have decisions of this court which we would like to place. We just need to search them out where it has been said, even if the name appears in the draft NRC or the final NRC and it has not yet been notified to us, and it has not yet been notified, so it cannot be taken as a piece of evidence, Lordship. He cannot make two challenges together. Now he is relying on NRC also. If NRC fails, if he gets through, then he has he's got his relief. He's challenging both the things here. So he has to take up one, Lordship.
No.
What, because
the
the
challenge is made, can be anti-grounds.
NRC thing is yet to be notified. Government of India has not notified it till today,
That
Lordship.
is not a strong legal proposition because of the fact that your submission will be hit by order 2, rule 2, where it says that you can't file a successive writ petition or a suit challenging the different orders at different point of time. So every challenge has to be made together.
These orders have been discussed, which we're just looking at.
Yes.
We will place that order, Lordship.
Yes.
May fix another date after the vacation, Lordship.
No, it is pressing for bail. You can give it us at 2 o'clock. No problem with that.
Or maybe tomorrow, Lordship, we'll try to find it out.
At 2 o'clock, I can.
Yes.
Give it at 2 o'clock because tomorrow we
We
don't
will
want
do that,
to
Lordship.
tax ourselves. And on merit of this documents, next.
Lordship, it was also to be heard on delay in latches and maintainability, Lordship.
Yes.
We have not made our submissions yet. Do that fix one, Kali. Lordship can fix it up tomorrow, Lordship.
Tomorrow we have a long list,
Yes, Lordship.
very long list.
Lordship, we would like to address this court on issue of maintainability and delay in latches, Lordship. मैं फोन पे शुरू ये तो दूसरा fix हो गया time of matter ना Lordship may take this matter up at 2 o'clock, Lordship.
Okay.
At 2, Lordship. Mr. Paying will address this court on this.
Item 18 with 19.
Develop.
Lord, item 18 is challenging the declaration of the foreigner's tribunal. And at the time of filing of the writ petition, he was in custody. Because of the Supreme Court's order, he was released on bail. Subsequently, this honorable court also granted bail. And he was all along attending the Tarabari police station, my lord. Last he attended on 22nd May. But on 25th May, he was taken on custody.
My lord, the case is pending, my lord, before this one court, and he is all along attending the court. Police has taken him in custody, my lord. Now he is in a detention center, Matia. And apprehending that he may be deported very soon, my lord. That arrangement is going on.
No, this 3219 writ petition. This writ petition was filed, it has probably been dismissed.
My lord,
This writ petition,
pending dismissal. Huh? It is still pending, my lord. Not dismissed. So for our, my lord, information, my lord, is pending, still pending.
no, this writ petition, the 3219 has been disposed of.
My lord. My lord, sorry, my lord. In my lord, we have wrongly mentioned 32. My lord, 3219. It is in fact 3129. We have wrongly mentioned, my lord. I'm sorry. my lord.
3129.
Yes, my lord. 312.
Come along with that.
My lord, the order copy, my lord, I have annexed in the IA. 3129, my lord. Annex 30.
3129.
Yes, my lord.
Mr. A.R. Sigdal and counsel for the petitioner submits that this interlocutory application has been filed in connection with WPC 3129 of 2018. However, there has been an inadvertent mistake in on part of the counsel for the applicant to tag to refer to make a reference in this IA as if this IA was filed in connection with WPC 3219 of 2018. Full stop. Next, but accordingly, it appears that due to the said error, this interlocutory application has been tagged along with WPC 3219 of 2018. Next para. In view of the submissions made by learned counsel for the petitioner, let this interlocutory application be detached from WPC 3219 of 2018, and it should be tagged along with WPC 3129 of 2018. Next paragraph. List on Thursday, 26/6/2025.
My lord, may I pray for my lord, observation that he shall not be deported. He is in custody now.
Okay. Is the next date of this week, comma, the applicant.
My lord, in 19, my lord, the petition rightly correct and tagged, my lord. It is tagged, my lord, rightly.
Huh?
Here, my lord, in item 19, the writ petition, my lord, WPC 3129 2018. It is rightly tagged. Our mistake, my lord, ignoring, my lord, the officers, my lord, tagged with the right case, my lord.
No. In your cost title, you are writing 3219.
Yes, my lord. That should be corrected. We will correct, my lord.
Okay. Just before list on so and so, say, just before that, you say, before the last one, you say, till the next date of listing, comma, the applicant, namely, there's in 3 alias, so and so, alias so and so, alias so and so, shall not be deported out of the country.
D2. D2 is bill. 2 bill. Yes. 2 bill.
Next one, the petitioner shall produce a certified copy of this order before the Superintendent of Police, border, Borpeta.
My lord,
List on.
at that time, my lord, the case was of Borbet, my lord, at Guwahati, my lord. Superintendent Police City Guwahati, my lord, at that time we have filed.
No, in your, acha. No, in your cost title,
My lord, this petition, my lord, cost title is,
no, in the cost title, response number 7 is Borpeta.
my lord, in my lord, response number 3 in this case, my lord, Deputy Commissioner Police we have mentioned.
No, that we don't know. Which is right, you tell us, we'll put that.
My lord, at that time, writ petition, we have made party city superintendent. Now, my lord, the designation stands, so we have correctly made in the IA, my lord, the Deputy Commissioner Police Kamrup Metro.
Okay, then don't say Superintendent of Police border. You say Deputy Commissioner of Police within bracket border, Kamrup within bracket M, comma Guwahati. Okay.
My deep levels.
D 2122 for hearing.
In item 20, there is an order passed by your lordships on 4th of February, where the question of maintainability was highlighted. And my learned friend was asked to address the question on maintainability. The judgment that was referred in the case is 2015 9 SCC page 1. Here, my lord, the writ appeal that has been filed, my lord, it arises from an order of the Honorable Single Judge, where a civil division petition under 227 as well as writ petition under 226, both were decided together. And in the 4th February order, my lord, the Honorable Court has already formed an opinion that basically it's an order wherein 227 jurisdiction was exercised and therefore writ appeal will not be maintainable. If your lordship will kindly see the 4th February order.
Let him make his submissions.
Yes.
Let him make his submissions. We'll hear you.
Well, here I have two options, madam. On matter is the Honorable Court on 4th February asking the witness, if there is order, madam, is CRP and as a writ petition order was, madam, first common order, madam. So, madam, whether writ appeal is maintainable or not, madam, that is, madam. If not maintainable, madam, this might, they all writ petition, writ appeal, madam, the issue is same, madam. Issue is regarding the interest of 34, madam, whether they are entitled 34 interest, madam, of the old land acquisition act, madam. This is, madam. So all matter is together, madam. And madam, item number 22, madam. In this case, madam, the service is not complete, madam. Item number 22, madam. 22, madam. Last order, the as per office note is the office note there is there, madam. And 26 20/6/25, madam. The notice respond number 4 answer return, madam, and respond number 3 to 8 neither ED card nor unserved notice received, madam, is there, madam. So issue the all cases are same case, madam, regarding the 34 interest, madam.
As far as 22 is
concerned, let him complete.
No, my lord, I'm just indicating it is also not between the same.
We'll hear you. You are running away.
No, my lord, I'm just saying that that item is somehow it has been tagged together, but it is a different item.
Let him make his submission.
Yes, so it is my duty to point out this in that case, madam, this already appeal is admitted, madam, and the stay order also there, madam. And item number 21 and 22, my lord,
Just one by one.
yes, my lord.
In the first item, there is a writ petition 19 of 2023.
Yes, my lord.
Where is that available?
Judgment, my
Which
lord.
page? No, the writ petition is available in which page?
Writ petition, my lord, in first item, my lord. First item, my lord, writ petition available, my lord.
Page 44.
Yes, my lord,
Page
44.
44.
44, my lord.
Correct.
The running page will be 72 perhaps.
Mr. Mehdi, where is that part of the, what do you call, that part of the order passed?
Which-
Challenging of the, uh, changing of the challenge to the order dated 11/11/2022 in this impugned order,
Yes, ma'am.
impugned judgment. Where is the challenge to quashing of 11/11/2022 decided?
My lord, is
Okay, we'll continue after lunch.
yes, my lord. But 11/11, it was made only for the district collector pass an order to allow the 34 interest, my lord. So here, my lord,
So whatever we, but where it has been dealt with?
there is not specifically, it was not, it is from page 215, my lord. There is some paragraph from 10, my lord. From the project made by the parties issue consideration, firstly, whether execution could have come to finding that the landowners are entitled payment of.
Okay, we'll take it up at 2 o'clock.
Yes, my lord. These,
It's okay. We'll take it up after some time.
relevant portions start from page 211. Paragraph 2, my lord, it is mentioned about the CRP, my lord.
Yes.
Challenging the order of the court below, my lord. And thereafter, my lord, paragraph 3, my lord, is regarding the writ petition, my lord. I'm reading paragraph 3, my lord.
No, don't read that. We just wanted to identify
Yes, my lord. Yes.
which part of the order is writ petition, which part of the order is the CRP.
Well, CRP, my lord, this only that part, my lord, is in CRP also, my lord, consequential order is 1111, my lord. The court.
1111 is annexure F to the writ petition. Where is that document?
Yes, my lord. Annexure F. Annexure F is page, my lord, 154, my lord.
154.
Yes, my lord. May I, my lord?
From the date of possession
Yes, my lord.
at 9% and thereafter 15% on expiry of 1 year.
Yes,
So this was under challenge.
yes, my lord.
Now, how is this part dealt with in the
My lord, this lordship may turn page 215, my lord. Paragraph 10. Because my lord, the CRP and the requisition was taken together, my lord, so the issue, my lord, the 4 issue was, my lord, framed by the court below, my lord. From the project made by the parties, 4 issues arises for consideration. First, whether the execution court would have come to a finding that the landowner are entitled to payment of interest so-and-so, and so also amount solicium under section so-and-so, all statutory benefit under the act. Second, whether the execution court could have relegated the landowners to the district collector with their claims for payment of interest under section 34 of LA Act. Thirdly, whether the district collector could have awarded a statutory interest under section 34 of the LA Act to the landowners. Fourthly, whether landowners would be all entitled to payment of interest under section 34 of LA Act from date of possession of so-and-so, up to the judgment, date of judgment by reference court, LA number 42 of 2015, my lord. Here, my lord, the first issue, my lord, is the execution regarding the execution court, my lord. In that case, my lord, we have, my lord, the execution court has power, my lord, as per judgment of Sundar, my lord. This so far section 23(1)(a) and 23(2), my lord, the interest can be given by the execution court, my lord. We admit, my lord. And so far the second issue, my lord, since execution court did not take any decision on the issue, therefore same request no further or separate deliberation. This was, my lord, the second issue was whether the execution court could have relegated the landowners to the district collector with their claims for payment of interest section 34.
No, then please come to the, please answer one query. Number 1, if an interest is granted by virtue of page 154, this is by the district collector.
District collector, subsequently, my lord.
No, whatever be, but it is by the district collector.
Yes, ma'am.
How is the district collector's order challenged, put to challenge?
Yes, my lord, before that, my your lordship, may turn, my lord, this the order of the reference court, my lord. It is starts from page 85, my lord. Relief and portion is page 124, my lord.
Yes.
This award under section 26 of LA 1894. District collector, the deputy commissioner clerkship shall predetermine land value of the applicant under section 28A of LA Act. There are 25 per square feet within a feet or 1 week from the date of receiving the certified copy of the judgment award. And the applicant landowner shall also be paid solicitation interest 30 in addition to the land value along with the interest 12 per annum from the date of notification under section 4 of the act
to the date of the respective award number 1 of 2012 as per section 23(1)(a) and section 23(2) of the Act. The district collector Gulasip shall intimate the general manager to satisfy the award amount through deputy chief engineer NF Railway Silsar at Barbary. And said award amount shall be paid by the general manager NF Railway within a period of 3 months from the date of receiving the intimation from the district collector and
Just a moment.
In order for the company to pay the transporter order, direct tax. This is a provision bunch.
Last line is important, madam. Last line, madam. And in this case, failing to pay the market and land value within the stipulated time, the landowner shall be entitled to interest under section 34 of the Act with immediate effect from 17 January 2015 till full final payment. This order was passed on 18 January 2017. Madam. So from that, if we fail, madam, then we are then liable to pay interest 34, madam.
Combination. Strictly non-vegetarian, it was strictly vegetarian. So তার মাঝে তুমি কেস করে গেছে আর এদিকে মাঝে মাঝে এটা স্ট্যাম্প লাগা থাকে
My lord.
Mr. Datta?
Yes,
We
Milord.
also and to Mr. Mehdi also. Insofar as that part of the challenge is concerned, with regard to the CRP, we'll have to say that this, that will be, the appellants will have the remedy to assail that order as in the forum as he may be so advised. Because rightly or wrongly, there's an order passed in the CRP. It's a common order. So one part of the common order has to be challenged, the forum available to him.
Now, on 4th of February, my lord, the Honorable Court formed an opinion that in fact, the kind of jurisdiction that the single judge has exercised in the matter is pertaining to 227. And therefore, this writ appeal will not be maintainable.
Whatever you say, whatever language you used, the fact is that there is a CRP.
Yes.
Yes, ma'am.
So in CRP, that order was passed. Whether it is a CRP under 226 or 227 or under 115, we leave it to the appropriate court to decide that matter.
Yes, yes.
Because he has to have a forum to challenge that order. Against the order of the writ petition, a writ appeal would lie insofar as the challenge which is inherent in that for that part of the order, which is essentially a challenge to the order in the CRP, that has to be taken up separately.
Yes.
Yes, ma'am.
That has to be taken up separately. And I'll go, my lord, in my submission one step further. The other parts which have been taken into challenge in the writ petition, these are basically consequential orders passed after passing of the order in the reference court. So therefore also, my lord, the sum and substance of the matter remains that in fact, my lord, it's a determination by the honorable single judge, which is in the nature of 227. And therefore, this writ appeal will not be the appropriate recourse.
So that will hear you.
Yes, for that matter, my lord, I be relying on some precedents.
Yes. So far as
But
this challenge is concerned, we
as far as 26th October order is concerned, my lord, that cannot be a subject matter of challenge in the present.
There is not here subject matter of challenge, ma'am.
No,
Subject
ultimately,
that
since
is-
it's a common judgment.
you elect. If it is not there, then we don't pass any order. Then we just record your statement that that is not under challenge.
Which one, my lord?
26/10/2022.
My lord, in this is writ appeal is filed, my lord, against the judgment of this writ petition, my lord. In writ petition, my lord, this challenge was, my lord, 11/11/2000.
No. You see, I'm having a very targeted approach.
Yes, ma'am.
The first question is any part of the order in the one of your challenge was the writ petition as well as you had filed a CRP,
Separately, yes.
correct? And this is a common order in writ petition and CRP.
Yes.
In this appeal you have filed, is the order under order in respect of challenge under challenge in the CRP, is it here or it is not there?
My lord, this common order is here, my lord.
Please say when we are passing order, then you said that no,
Common order is,
we are not challenging it. That's the statement you made.
it is common order, my lord, so it is here, my lord.
Whether it's a common order or not, I don't know. I'm asking you, as I don't know, that's why I'm asking you. You made a challenge, certain challenge in the CRP. And in this common order was passed in writ petition and CRP. CRP part is under challenge here or not?
CRP part is, my lord, lordship, and here is my this prayer, my lord.
We are in the writ appeal.
Writ appeal, well, prayer and writ appeal, my lord.
In writ appeal, there's normally no prayer made.
No prayer.
You only have a
Certificate.
Prayer is there, my lord.
That is not an appropriate form. In a writ appeal, we don't expect a prayer.
Yes, my lord.
Yes.
And page 41, my lord.
Yes.
In the premises, it is humbly prayed your lordship may be pleased to admit this appeal called for the record so and so set aside it was the impugned judgment order 1/6/2023 passed in WPC number so and so along with CRP. And
So this CRP we are excluding.
Yes.
CRP, there can't be a writ appeal in CRP.
Yes, my lord. CRP can. But here, my lord, there in my senior friend's place in judgment, my lord, where my lord, it is before his honorable court, my lord. There's one paragraph I am reading, my lord.
Which judgment?
2015 9 SCC page 1.
Paragraph 28, my lord.
Just a moment, let my esteemed brother get it. This is the first one.
Page 25.
Okay.
Sorry, opinion.
Yes. Yes.
Judgment is there.
Yes, I have it.
Sir. Page 25, my lord. RM Lohila, the Justice Director, my lord, 36. If the judgment under the appeal falls squarely within four corners of Article 227, it goes without saying that inter-court appeal from such judgment would not be maintainable. On the other hand, if petitioner has invoked the jurisdiction of the High Court for issuance of certain writ under Article 226, although the Article 27 is also mentioned, principally the judgment appeal against falls under 226, the appeal would be maintainable. What is important to be certain is that is the true nature of order passed by the single judge and not what provision of the provision he mentioned in while exercising the powers. We agree. It cannot take away the right of appeal against judgment if authorized found the exercise under 226. The vital factor of determination and maintainability of inter-court appeal is necessary, invoked by the party and true necessary of the principal order passed by the single judge.
See, there is a small fundamental issue here. In a recent judgment which is authored by a single judge of this court, it has been clearly stated, and I would rather follow it. You see, incidentally, our High Court does not have letter pattern under Section 15.
Yes.
And under Section 15, because we follow the Calcutta, what do you call, the what's it called, letter patterns of Calcutta, where it is 14. And even there, we don't have the challenge to the order of CRP before the division bench. It can't be made. Now, in this order, which we have just seen an overview, we have not intrinsically examined that order. But that order is, there's no dispute in that order whether the High Court was exercising jurisdiction under 226 or 227. The two different separate proceedings was taken up together.
Yes, well.
So the question of jurisdiction was never there. It's in some cases when we order, what do you call it, some order is challenged, and to here also in this court, there are many orders which are challenged both under 226 and 227. And therefore, when the order is passed, essentially is 227. Sitting singly, if I get it, I always say that you strike it out. Either 226 must be struck off. So, but always that order is not passed, and therefore, in such cases where essentially a civil dispute is taken up, then this question would arise, Jogendra Singh ji, Vijay Singh ji, whether it is an order passed under 226 or 227. Here, that is not in dispute. You can't file a CRP and then say, I was moving at 227, 226. Therefore, that part of the challenge, even as per your pair, has to be separated.
Yes.
Whatever happens to this is in a different consequence, but that part has to be taken up separately.
Yes. That part, my liberty can be given, my lord, because the stay order is there initially, my lord. This stay order was there, my lord, initially stay was operating, my lord.
No, we are in agreement. In fact, we can't extend the stay once we say that we don't have jurisdiction. But we'll give you protection by saying that the time spent here from the filing of the writ petition, writ appeal till today
Yes, sir.
and 1 month beyond, it will be treated as a time spent in a wrong forum.
My lord, what happened, my lord, there is an execution case is pending, my lord.
Hmm?
Execution case is pending, my lord. So, my lord.
You have to deal with it because once we don't have jurisdiction.
My lord, this stays, bracket, my lord, is till, my lord, the filing of the, my lord, till date, my lord. I did that much.
Because we will not have jurisdiction. Once we say we don't have
Yes,
jurisdiction,
my lord.
can a stay be extended?
My lord, till, my lord, filing, I've given liberty.
I'm asking you a question. If we don't have a jurisdiction, can we grant a stay?
My lord, initially, my lord, rightly wrongly, their stay order was given, my lord.
That's okay. We are not questioning that.
I pray it is only till filing, my lord. Till filing of the, I will, before the appropriate from, my lord. Because.
Sorry, that can't be accepted.
My lord.
That cannot be accepted. Once we don't have jurisdiction.
Huh?
Your stay would still continue in the writ petition. The stay, does it say that stay in the CRP and stay in the writ petition? No.
In a writ petition, it is reflected they are entitled 34 interests, my lord. My lord, what happened 34 interests, my lord, here, my lord. There is my two type of person, my lord. My lord, initially, my lord, immediately first when award was passed, my lord, we have paid immediately, my lord, that installment, my lord. Immediately, my lord, we have paid this all amount, my lord. That is, my lord. That was not reflected in the judgment also, my lord. They by learned single judge, my lord. My lord, 2013 itself, we paid the entire amount, my lord. Thereafter, this LA appeal was filed, my lord, and they in that case also this judgment order was passed, my lord, from the particular date, my lord, if not made paid, then we have to entitle 34 interest, my lord. When thereafter, my lord, the execution court, when taking the execution court, my lord, they, my lord, given liberty to file separate application before the district collector. Then, my lord, district collector, my lord, this was an order. From the date of possession, the subsequent enhancement, the rate, my lord, they are entitled. But the compensation part is there, my lord. So far, 34 interests, my lord. Compensation. This
whatever. These are question of fact. These are questions of fact.
Yes.
Whether the position was taken at before the land was acquired. That is the only parameter of section 34.
My lord, certificate was given. It is not. I have not annexed, my lord. It is there.
You see, we are asking you a question that section 34 of the LA Act merely requires that if compensation is, whether the compensation is paid before acquisition, and then there's a separate procedure for the, interest. And if the land possession is taken before, then the compensation is paid. But the compensation is paid before acquisition, and then there's a separate procedure for the interest. And if the land possession is taken before, then the compensation is paid. And if the land possession is taken before, then the compensation is paid. And if the land possession is taken before
We have not taken before, my lord. We have subsequently, when my lord, the position was given.
That you'll have to.
That is my the case, my lord. Immediately after my lord, get these compensation are paid, my lord. After we take position, my lord. Now, my lord, in reference could also it is ordered, my lord. This we have
Mr.
to
Mehdi, you may have a very good case, but can we, without, while saying that we don't have jurisdiction, can we extend the stay?
So far, I only pray my lord, this till filing my lord, the interim protection may begin, till filing my lord. Because otherwise, my lord, this huge amount, my lord, the government will they will have to pay, my lord. The execution code is there, my lord. This amount is very, very high, my lord. So the execution code is against us, my lord. That is our problem, my lord. So till filing, my lord, the lordship may, whether this, we can file review or the SLP also, my lord. Because Supreme Court is also, my lord, there is a holiday, my lord.
Once we don't have jurisdiction, how can we give a stay?
My lord, a small prayer, my lord, this already it is, my lord, it was, I filed this case, my lord, 2023, my lord. My lord, this, and the interim order was passed on May 2024, my lord. So only 1 month, my lord, is, my lord, my lord, so far only that part, technical part is against us, my lord. This, their CRP and the repetition is, this order was passed together, my lord. But my lord, the other part, we have decision of the apex court as well as the other high court also, my lord, they are not entitled 34 interest, my lord. So I'll not argue because the jurisdiction part is concerned, my lord. So only 1 month time we granted, my lord, till that, my lord, within we'll file the appropriate petition. And other, my lord, 34 interest, my lord, those entitled, we have already paid, my lord. Other 34 interest, my lord. Whatever after, my lord, 2017, my lord, till that, my lord, this, that part we have already paid, my lord. We are not, we are agreed, my lord, from 2017, from the date of possession, my lord. And that part, my lord, as per law says, my lord, the compensation was paid, my lord, section 11, my lord, this award, and immediately we paid the compensation. So they are not entitled, my lord. After 17, we paid all compensation, there is on the before.
Okay, that part we'll consider when we retire in the chambers. Right now,
My lord, this
we'll take into consideration, but right now we are not inclined, but we'll decide when we retire. We'll deliberate and then we'll pass orders.
My lord, in this petition also, my lord, one order was passed in CRP. Some, my lord, it is reflected we have not paid, my lord, in the order, my lord. But do we have our statement? We have already paid that amount, my lord. Immediately after, my lord, the award was passed. Section 11 award passed, my lord. And my lord, I have documents also, my lord, from the.
That you don't bring on record. Then we merely adjourn it for the reopening if you want to file that.
Yes, my lord. Then, my lord, I will some time I give.
Because we are not inclined. Once we say we don't have jurisdiction to extend the stay is something we will not do. We would have deliberated inside, but.
Well, this super this that part, my lord, we have paid the entire amount, my lord, the initial award, my lord. That is, we have that record with us, my lord.
Okay, we fix it on the reopening day. You file your affidavit by then.
Yes, my lord, we'll file.
Let him file that document. Mr. S.K. Mehdi, learned counsel for the appellant, by referring to the order dated 4/2/2025, has submitted that insofar as that part of the challenge which relates to the order passed in CRP 2 of 2023, he has no objection in principle to close the matter with liberty to the applicants to take appropriate records to challenge it in an appropriate manner, as the applicants may be so advised to stop. However, comma, he submits that there is a factual error which has not been clearly stated in this appeal, comma, which relates to payment of compensation to the respondents. When the award was, land acquisition award was passed under section 11 of the
Yes.
Land Acquisition Act, comma, 1894. Stop next para, accordingly, it says that he may be given an opportunity to file an additional affidavit, to bring such materials on record. Next para. Mr. S. Datar and Senior Counsel, assisted by Ms. Aidas, Learned Counsel for the respondents. You are also there?
I'm in the second report.
Okay. He is present. Puspa. Next caller. List on 14/7/2025. And in the second case, second item, you say that
Second case is from my, we have paid entire amount after initial award, and that also I'll file a affidavit.
okay. Same order. You have the presence of Mr. P.D. Nair as counsel for the respondents. 1 and 2. And you are for? Acha, Ms. P. Bhattacharya, and additional advocate general for the state of Mizoram are present. Same order. And sorry, in the second order, you don't say about that CRP. You only say that the second part of the order, not the first part. CRP.
The third one, my lord, I did 22, my lord, the service is not complete, my lord. I filed, my lord, yesterday, filed an IA, my lord, for praying for paper publication, my lord. It is not.
No, you can't do that because there is an order somewhere I read.
My lord,
it was
justice services to concern, my lord, is not possible, my lord. So
then you'll have to tell us. Even that you'll have to tell us.
Yes, my lord. In our my lord petition, my lord, we have reflected, my lord.
In your petition, you have said that.
Yes, my lord.
When did you file it?
Yesterday, my lord.
It's not on record.
No, not on record. The filing number is there, my lord.
Okay. In this item 22, you say that Mr. S.K. Medi, done a CGC for his CGC, not as advocate. That's S.K. Medi CGC submits that and affidavit, you have filed an affidavit?
I filed an
I has been filed in the matter, which is not on record. Next para, let this set. IA be tagged with the IA filed by the appearance be tagged on record. List on 14/7/2025.
File.
Okay. There also you are appearing in here also you record. Ms. P. Bhattacharya, additional advocate general for the state of Mizoram is present.
File. This very recent decision of Supreme Court Lordship. Copy अपना ये सो এটা copy আছে page 5 Lordship, paragraph number 19.
Give me some under the citation, otherwise
Yes,
it will be handicapped.
Lordship, issue number B, as regards the effect of inclusion of the name of the appellant in the draft NRC, which was published by the competent authority in 2018. It would be opposite to notice Rule 4A of the Citizenship, Registration of Citizens and Issue of National Identity Cards, Rule 2003, as inserted by so and so. Rates does. Then Lordship, after discussing all these provisions, Lordship, Supreme Court come to the conclusion that for reasons detailed above, the inclusion of the appellant, inclusion of the name of the appellant in the draft NRC would have no bearing on the order passed by the tribunal affirmed by the High Court declaring the appellant as a foreigner, Lordship. This is very recent decision, Lordship, decided on 19/5/2025. Yes. On earlier occasion, Lordship, our High Court also decided this aspect, Lordship, on several occasions, Lordship. Welcome to our High Court, Dada. এই প্রথমটো সুপ্ৰিম কোৰ্টতো দিলো এতিয়া চিৰাজালিতো দিছো তাৰপিছত এই সোফিয়াল বেঞ্চ Lordship, in Shirazali case, Lordship, this Honorable Court decided Review Petition 184 of 2019, Lordship, decided on 5/12/2024, Lordship. I'm relying on paragraph 9, Lordship, in this case.
Yes.
Para 9, Lordship, what Honorable High Court has said, Lordship, the learned senior counsel for the petitioner has claimed that the final NRC had been published on 31/8/2019, and in view of observations made by Apex Court in Abdul Quddus Supra, the claim of the petitioner should be re-examined as their relatives had been included in the final NRC. In this regard, it may be seen that the publication of the supplementary list of NRC after examination of claims and objections under paragraph 6(3) of the schedule under Rule 4A4 of the rules of 2003 is to be done by local Register of Citizens registration. Thereafter, the Register General of Citizens registration is required to publish the final National Register of Indian citizens in the state of Assam. But Lordship, that final list was not yet published, Lordship, in this regard. There are no materials, after that I am reading, Lordship, there are no materials placed before us to show that the Register General of Citizens registration has accepted the publication of supplementary list by the local register and published the final list. In the absence of such exercise, the final NRC, which is relied upon by the petitioners, cannot be accepted to be a ground for reviewing the judgment and order dated 31/1/2018 passed by this court. Further, as regards the case of Abdul Quddus Supra relied upon by the petitioners, it may be seen that question of persons aggrieved having liberty to invoke. No. I think it is not necessary, Lordship. Then, Lordship, again in Lordship, I am relying another case, Lordship, WBC 1065 of 2018. একটা কপি করলি দাদা কেন পাই যদি আরো একটা কপি দিতে না 1065 of 2018.
Paragraph?
Paragraph, Lordship, page 4, para 16, Lordship. Page 4, para 16, I am relying, Lordship.
Yes. 16.
Yes, page 4, para 16.
Please read.
Hmm?
In the internal parameter. This is.
Internal para, yes.
Yes.
Please read.
At this stage, it may also be mentioned that in WPC number 274 of 2009, filed by Assam Public Works, which is pending before the Supreme Court of India, wherein NRC updation exercise in the state of Assam is being mentioned by the Supreme Court of India on 25/10/2013. The Supreme Court clarified that as far as persons in the list are concerned, undoubtedly they were doubtful voters, and therefore their names could not be included unless the NRC is updated and unless the foreigners tribunals declared them to be Indian citizens. Lordship.
Okay.
So, Lordship, from the
Yes.
So, Lordship, after discussion, after reading the paragraphs mentioned in the citations, Lordship, it is clear that mere inclusion of the name in the NRC, Lordship, it could not confirm one citizenship, Lordship. And Lordship, regarding fact part, Lordship has already pointed out, Lordship, in no way proceedings connected with the persons whose names reflected in the 1966 voter list, Lordship. And Lordship, in orders also, opinion also, Lordship, in paragraph in page 101, Lordship, it was from bottom second paragraph, Lordship. I am reading, Lordship. Page 101 of the writ petition, Lordship. During process examination.
Just a minute, let us come there first. 101,
Page 101, Lordship.
yes.
Second paragraph. During cross-examination.
Yes.
During cross-examination, the witness DW2 stated that his father Mofez Ali was died about 5-6 years ago, and DW3 stated that his father Mofez Ali was died about 8 years ago, whereas OP stated that his father Mofez Sheikh was died about 40 to 45 years ago. The apparent contradiction striking at the relevancy of exhibit and the voter list of 1997 appears in the name of Mofizuddin along with Jovida Khatun and Javed Ali. It is a legitimate question that if Mofez Sheikh was died about 40 to 45 years ago, how his name enrolled as recorded in voter list of 1997. From this contradiction, it is apparent that Mofez Ali and Mofez Sheikh are two different persons. Going by evidence of DW2 and DW3, it cannot be said that said for sure that they are brother of the opposite party. Thus, the evidence of DW2 and DW3 are wholly unreliable and could be of no assistance to the OP. And Lordship, there are some age discrepancy regarding mother and son's, Lordship. That was also reflected in page 100, second paragraph, Lordship. And Lordship, in WS, Lordship, they were totally silent regarding name of her name of his mother, Lordship. So Lordship, he and Lordship, name of these two brothers also not, Lordship, introduced, Lordship, in this in the WS, Lordship. Good. Lordship, yes, sir.
So Mandal, anything in reply?
My lord, only, my lord, my respectful submission, my lord. Since the final judgment has been, my lord, come out on 17/10/2024, whereby the, my lord, final NRC has been, my lord, given clearance, my lord. And my lord, my friend has referred the one judgment which has regarding the, my lord, draft NRC. Mine is not the draft NRC, mine is the final NRC, my lord. That must.
Only one.
What is that judgment which you said that?
Yes, my lord,
NRC?
a writ petition number, my lord, we are having the one copy, my lord, part copy is there, 400 paper. My lord, writ petition number 274/2009.
You give a copy, you will take it, get back
Yes,
tomorrow.
I'll
You can take it back tomorrow.
Yes, I'll get the copy.
The courtmaster will give you back the copy tomorrow.
The one thing I would like to clarify, my lord, your lordship, kindly see the NRC rules 2003.
Which page of this book?
This book 133, madam. Appellate provision I wanted to show. That has been discussed in the judgment also, madam. That we make clear. Appeal the section 8, madam, after rule 8. Any person not satisfied with the outcome of the decision of the claims and objection.
No, Mr. Mandal will not file an appeal.
No, madam.
Because he says that it is his final, so he is not agreed by that.
No. What my attention is, my lord, the ordinance tribunal is the appellate authority of the NRC, my lord, authorities. So NRC authorities cannot go beyond the foreigners tribunal. My lord.
That we don't know.
Yeah. No, that is
That is two separate jurisdictions.
no.
What we do
Yes,
in
yes,
two
yes.
separate jurisdictions, we don't know.
No, my lord, in Abdul Kutur city said, my lord, foreigners tribunal, it will come res judicata. This foreigners tribunal and that foreigners tribunal will come res judicata, my lord. Once that tribunal has decided, this tribunal cannot reopen the matter, my lord. That's why that is the my lord, ratio laid down in the Abdul Kutus matter. That's why, my lord, this is
So
met.
that issue will never arise. Why? Because the tribunal has declared him to be a foreigner.
Yes.
And so far as he says that the Supreme Court judgment says that the final NRC is final.
Yes.
Therefore, this appeal, who will be the person who will file this appeal?
No, my lord, what my contention is that they are claiming that as our names are in NRC, even though we have been declared foreigner, our case may be looked into by the Honorable Court or like we are citizen. Now the Abdul Quddus says, my lord, as your lordship has already seen, it is said once you have been declared foreigner, you cannot be included in the NRC. Suppose in the NRC someone's name appear, my lord, somehow. So the other party will go for appeal, or they may be given a rejection slip. Now, my lord, if his name is not included in the NRC, he could come for, my lord, before this foreigners tribunal. But the Abdul Quddus says, no, you cannot, because the tribunal has already decided. Foreigners tribunal has decided. So even though your name is included in the NRC, excluded in the NRC, so you cannot go to the, my lord, this foreigners tribunal. It will come as res judicata.
My name has been appeared in the final NRC.
No, final NRC.
I did not file appeal. Once.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 15. Well, in this case, my lords, the learned senior colleague, counsel, my lord, he is due to personal difficulty will not be able to appear today, my lords. Kindly the matter be passed over for the day, my lords.
Okay, 15 password day is prayed for by the counsel of the petitioner. CBI, who's there?
I've informed her, my lords.
Okay. Standing counsel, the respondent is present. Okay.
I'm so blessed. Yeah, ma'am, I informed her already.
Okay.
Password for the day.
Password, but not by tomorrow, thereafter. Because tomorrow I'm a bit busy, that is why.
Okay.
So they are asking for tomorrow. Today we are waiting
I'm not
for
asking
the
for tomorrow, my lords. We're not asking for tomorrow.
No,
day after tomorrow. Day after tomorrow, any day.
Any day after.
Okay.
Much obliged.
You recorded your presence.
I'm so sorry, my lords. It can be recorded any day after tomorrow. Any day after tomorrow, my lords.
Day after tomorrow, we are already fixed.
Or then Friday, my lords. Friday.
No, not on Friday.
Okay. I'm obliged.
Day after tomorrow is Thursday.
Day after tomorrow is Thursday.
Friday, we are not fixing any matters.
I'm so blessed.
Worship item 14, whether I am also paying for day after tomorrow. Item 14.
14. Same order.
That's payment.
Okay.
I'm deeply appreciative.
Item 1 for motion BA.
Yes.
This application under section 483. Here in this case, my lord, the petitioner is in judicial custody since about 219 days. My lord, after filing this FIR, my lord, charge sheet is submitted. Thereafter, my lord, matter is registered under say special case, and trial is started. Thereafter, my lord, victim is one witness. Victim is examined, my lord.
My lord, POXO matter.
This POXO.
Okay. Uh, Mr. Chaudhary and counsel for the petitioner is and Mr. K. Bhushan and APP for the state are present. Next, issue notice on respondent two. Returnable.
My lord, here in this matter, my lord, respondent number 2 is not included, my lord.
No, is there?
My lord,
Is Renu Bora?
my lord, in the cost title, my lord.
No, subsequently, it was.
Oh, my lord, that was correct.
Oh, give a copy to him. Give a copy to him. Otherwise, it's wrong on your part.
What happened, my lord?
Whatever has happened, give a copy to him.
I'll.
My lord.
I'll.
Respondent number two, returnable on 24/7/2025. 23/7/2025. So the petitioner shall take steps within 2 days for service of notice on respondent number two. Next, the registry upon receipt of the steps shall process the same and hand it over to the learned APP, to the office of the public prosecutor Assam for service on the respondent two through the jurisdictional Nunmati police station.
My lord.
And the report of service shall be returned to the court prior to the next date of listing. Next file list on 23/7/2025. Before that, objection to any by the state be filed by them. List on. Yes.
Item 2.
May I please lordships. In this case, my lord, petitioner was, my lord, arrested on 8/5/25, my lord.
Okay, same order. You have to give notice to respondent number two. Same order.
This is, my lord.
Mr. S. Ahmed, land counsel for the petitioner. Mr. Bashir, IAB for the state. This will be which police station?
Bizni, my lord, the district of Siran.
Bijni police station. Take it 3307. $37.
Along with, my lord, medical report and the statement of the victim, my lord. Otherwise, sometimes, my lord, the medical report, my lord.
Okay. In the meanwhile, the learner APP shall obtain the scan copy of the case diary. Scan copy the relevant pages of the case diary along with medical report.
Medical report and statement of the victim, my lord.
Medical report and statement of the victim to be produced in copy of the statement of victim to be produced in a seal cover.
My lord, what is informed is that Sarsit not submitted. So, my lord, can we call the entire city, my lord?
We have just relevant pages we have said. Whatever you want to call, you can call it.
My lord.
Because we don't want to stop the investigation.
My lord.
So that's why scan
Only relevant part, my lord.
and insofar as this statement is concerned,
My lord.
you will get it in seal cover.
My lord.
Photocopy in seal cover.
My lord. My lord.
Copy in seal cover. And or scan copy of the statement to be produced by the Rwanda APP in seal cover.
My lord. Obliged.
Obliged, my lord.
Three zero. Yes, item 3.
May please, your lordship. The regular bail application, lordship. The case is registered under POCSO Act, lordship, section 6 of POCSO Act, lordship. Lordship, here case diary along with the notice may be issued, lordship. The informant has been made party, lordship. The FIR.
Same order. Mr.
D. Mehdi, lordship.
D. Mehdi, counsel of the petitioner. Notice to be served through the jurisdiction, Sadgaon Police Station on respond number 2. This is application for bail under section 483 CRPC, for offense under page 2. Next page, ABP shall produce the relevant pages, scan copy of the relevant pages of the case diary along with same statement of the victim and a seal cover and the medical report. This is Satgam Police Station. We make it 23rd.
My lord, my lord.
So can it be little bit earlier, Lordship?
We are opening on
16 or 17?
we make it 18 July.
18th.
The
Because first week will be too busy. All the courts are fixing all matters after vacation.
deeply obliged.
They'll be will not be able to manage.
Deeply
Okay.
Item 4.
Yeah, so that there is also POXO, my lord. 82 days in custody. Lordship will find
Same order.
page.
This will be also as not and counsel with the petitioner.
Tamulpur PSO.
Notice on respondent 2. Musician Police Station, Kamalpur Police Station. Seems can copy the case diary on that. Kamalpur will be 30, make it 7/20/25.
Plus.
Motion AB. Item 5.
May it please your lordship, your lordship. This is a charge-sheeted case, your lordship. Registered, your lordship, under prohibition of child marriage act, your lordship. So father and your lordship, the son, your lordship, Asraful, I am for Asraful Alam, page number 2, your lordship. So father was already arrested, your lordship. And then already unlatched on bail, your lordship. My submission before your lordship is that I have been shown as abscondent in the charge sheet, your lordship. So an anticipated bail application has been filed, your lordship.
Yeah, we can't give you clearance bail.
So is there.
Because your lordship, the police doesn't have the power to declare an accused. And so for the information derived also, your lordship, 41A, your lordship will not be served on your lordship. So I'll cooperate all along, your lordship, in this.
You can just surrender before the court and they will take its own call.
Lordship, protection may kindly given, your lordship.
Not in POXO office.
Because they're living as husband and wife, your lordship. Since long.
You have to convince the trial court.
Only one, your lordship, 17 years of age of the girl, your lordship, as per the birth certificate. And so far the FIR is also indicated 17 years of age. And with the due understanding with the both sides, your lordship, they enter into marriage, your lordship. But your lordship, just a protection, your lordship. All along I will cooperate in your lordship. Till the conclusion of the trial, your lordship.
It's not a case for grant of
At any stringent condition, your lordship.
You surrender before the court and court will take its own call.
Then observation may kindly be given as well. Your lordship, in the there is a judgment of the Supreme Court also, your lordship, in Sushir Agoral versus State of NCT Delhi, 2025 at 61. It's a constitutional bench, your lordship. Even after
Yes.
Go off one night. I don't have the copy, your lordship, but here in this case, what it says, your lordship, held that even in succeeded case, the anticipated bail lies, your lordship.
We don't say no, but not in POXO offenses.
POXO, your lordship, lordship. The child marriage, your lordship, even a punishment is, your lordship, maximum 2 years, your lordship.
Section
9 as well as section 11.
Whatever is the punishment.
Punishment
surrender
is
before the
only
court.
2 years, your lordship, maximum, and 1 lakh fine. Either, not both, your lordship. So father is arrested and already got bail, your lordship. So son is all along willing to cooperate.
No.
In the next date, your lordship, just.
Heard. No, we are dismissing it, but we will give you liberty to approach the trial court, and they will consider. Because nowadays, all the magistrates are trained with regard to police declaring a conduct. They know these things by now.
Can be an observation. may
A.
continue.
Diwan, learned counsel for the petitioner. And Mr. K. Boishal and AVP for the state. Period for PRS bail under section 482 of the BNSS is made in respect of the petitioner who is apprehending arrest in connection with Sukhchar PS case number 87 of 22, page 2. Next, the General Counsel for the petitioner has submitted that the petitioner had married the victim with consent of the family of both sides. And they are residing as husband and wife. So it is submitted that the father of the petitioner was also arrested in the same case, but he has been released on bail in the meanwhile. The next, the Learned Counsel for the petitioner has submitted that in the charge sheet, the petitioner, the IO has declared the petitioner to be an absconder, which is impermissible in law. And accordingly, it is submitted that the petitioner apprehends that if he appears before the trial court, he may be taken into custody. Next para. The apprehension of the petitioner of arrest by the Special Judge Sarmara Mankachar appears to be out of place because by the order dated 27/3/2025, by which cognizance of the offence was taken, the learned special judge had issued summons for appearance to the petitioner, fixing 7/5/2025 for appearance. Therefore, no warrant of arrest has been issued against the petitioner. So therefore, the court finds no reason to issue notice on this bail application. Stop. In the event the petitioner appears before the learned trial court on the date fixed, the said learned court shall deal with the matter in accordance with law. Stop. With such observation, this bail application stands closed.
Item 6.
This is also offense under Malad POCSO Act. This second bail application earlier, one of it was rejected, Malad.
It was going to the same bench.
No, Malad, this bench was Honorable Justice Malasin Undi, Malad.
Okay.
This is this I'm paying for Malad call for city and notice.
Okay. Notice and respond to same POXO matter. Page number 1, offense. Charge sheet has not been filed.
Not filed, my lord, till date.
Okay, the APP shall produce the scanned copy of the case diary along with medical report of the victim and statement of the victim. It shall be placed in a seal cover. This is from which police station?
This is Madam Kolgasia Police Station. Kolgasia Police Station, Borpeta district.
Okay, notice. Jurisdictional Kolgasia Police Station. Okay.
Notice may be issued in the
Issue notice.
Master Police. Dates.
It will be Kolgasia will how much time? 23rd?
23rd.
23/7.
23. Master Police.
7.
Anticipated bail application matter. Charge sheeted matter, probably LCR will be required. Madam. Lordship will kindly see page number 33, madam. Charge sheeted under Capital Preservation Act.
We are dismissing our petition.
Madam.
Therefore, prayer as bill is being dismissed. Your before the trial court, your case is fixed for appearance.
Madam.
Law will take its own course. You are not warrant has not been issued. Your
Warrant is issued, madam.
no. You see, you are. It's not arrest. We issued
Bailable warrant.
bailable warrant because in the normal summons you did not appear. So therefore, bailable warrant. Your apprehension that police has declared you as an absconder
Yes.
is not coming the way of the court to issue notice.
The only issue is that the trial court, the SDGM, court of SDGM, will not be able to grant bail in this matter because it is triable by the special court.
Then say that.
Right.
Why are you making a wrong projection? You will lead to dismissal. Your ground is that he is. The police has no. You have spent a few paragraphs saying that
yes,
the police has no jurisdiction to write as absconder. Now, think yourself to be a policeman.
Well,
please write me an order. If you can't catch a accused, what will you write? Give me a paragraph. We'll circulate to all the police people.
my lord.
If police cannot catch a person who is an accused, please tell us how to write an order.
My lord. Then, my
We'll
lord.
circulate it.
Yes. But perhaps then, my lord, the police ought to have made an application before the jurisdictional magistrate.
You want that?
No, I'm not on that, madam.
We'll grant you a prayer. We'll ask the police to, instead of giving the summons, you move the court to declaring you as a absconder. Don't write unnecessary things in bail just before vacation. We have to read and come.
Madam.
Okay. Let the scanned copy of the case diary be produced by the APP on the next date fixed. This on.
My lord, that is a charge-sheeted matter, my lord.
Oh, charge-sheeted matter. Then
raised
raised from the court. Then say, heard Mr. S. Das, then constitute the petitioner. And Mr. Kiboshin and APP of the state. The shall call for the scanned copy of the charge sheet and documents appended. You already have filed a charge sheet.
Yes, charge sheet has been annexed, madam.
Then why we need another record from there? What record do you want actually from the?
Peruse the
CD
scan
part,
copy
madam.
of the CD,
Hmm?
CD part, madam. CD part of the charge, sheet. The case diary part.
Oh, no. We may not require that.
No.
You have to tell us why.
Then, madam,
Case diary is something which is within the domain of the court. If you think fit, we will follow it, not as a matter of right. The police may have many things not to disclose it to the public. That is why this CCTNS 5 have been implemented. If you need anything specific from that case diary, you tell us.
if the case diary is not produced, my lord, then my lord will be able to ascertain whether the police actually went to the house of the petitioner or not to trace him, my lord. Whether as they have mentioned that the petitioner is an
Can you
expert.
give an undertaking of the police in the case diary if they have gone to your house is found, then you will surrender before the police and not before the court in receipt of summons? Can you give an undertaking like that?
My lord will able to examine that, my lord.
What happens if it goes? Are you suggesting that the police will say that they were absconded without going there? In the case diary, he will not write. I'll tell you what he will write. I may be wrong in this. I'm taking a bail matters after quite a long time. I may have forgotten the language. He would have written, এতিয়া মই আসামীৰ ঘৰত যাবৰ কাৰণে আমি যত্নবান হলো. And then he will find that he has gone there and যাওঁতে আমি তাক লগ নাপালো. ওচৰৰ মানুহবিলাকে কৈছে তাৰ কোনো what is that language? কোনো নাই, সেইকাৰণে থানালৈ ঘূৰি আহিলো. That is the language he will use. No. You just give them time to objection, then you take it up. Don't need anything.
After vacation, then.
Yes, when should we take it up?
Any day after vacation. No?
It's a cattle preservation, we can take it up.
The date of appearance is in my lord 11/8, madam.
11/8.
8. 11/8.
Okay, then take it up on 16th, list on, as the charge sheet is available. Objection, if any, by the APP be filed by then. That the matter, there is no requirement of calling for any record from the concerned court. List on 16/7/2025. Mr. S. Das and Mr. Bishop. Yes, item 8.
Please, your lordship. Here is bail application, lordship. We will find the FIR at page 15.
15.
15. The long one, lordship. Married, lordship.
We'll call for the case diary.
Lordship, if your lordship comes to page 16, lordship, the police says in the FIR it has been written that at around 11:40 PM, a Bolero vehicle registration number so-and-so approached from the opposite direction. Then 2 persons step out from the vehicle and forcefully took the cattle from our position. Can it be possible, lordship, in Bolero vehicle, lordship, 3 kettles have been taken up?
And we have seen worse than that.
In Bolero vehicle.
Sitting here, we have seen worse than that.
And if your lordship comes to page 16.
In an extremely luxury vehicle, there are photographs of cattle being taken. Extremely luxury vehicle, cattle being taken. You have seen many things here.
If your lordship comes to page 16 for a moment, lordship. This is the medical report, lordship. prescription.
No, still very.
On 9:30, Lordship, on 2/2/25, I was admitted. Top of the,
No, you must have it. I have the case diary.
Lordship, kindly some protection, Lordship.
No, no.
On 9:30 on 2/2/2025, I was admitted to Kokrajhar Medical College and Hospital also. And in the FIR, it has been stated that at 11:40 PM, Bolero vehicle met with an accident. Admittedly, accident took place, Lordship. I have stated in paragraph 3 of my application, Lordship.
Let the case diary be produced. Case diary, scan copy thereof be produced. On. This is on which place?
Kokrajhar Police Station, my lord.
Kokrajhar Police Station. Make it 14/7.
Lordship, some protection, Lordship. I will cooperate with the investigation, Lordship. But
No.
I will appear before the IO also, Lord.
No.
With any condition, Lordship. I will appear before the IO. Accident took place at 8:45 PM and I was on 2/2/2025. And I was brought to the Kokrajhar Medical College on at 9:30 PM on 2/2/2025. Lordship. Page 16, Lordship. And multiple injuries are there, Lordship. If I am arrested and behind the bar, Lordship, it will be fatal for me, Lordship, because I am still undergoing treatment, Lordship.
No, no.
Some protection, Lordship.
No.
Because-
Case diary on. Make it 14/7. Item 9. Where is the FIR?
Where is it? See. Page 31. Make sure I have. My name was not in the FIR.
This is, you are the owner of the hotel.
I'm the owner of the hotel, but all the affairs are managed by the day-to-day affairs are managed by my manager.
Where is the entry of these people in your hotel? Yes. You are to required to keep iCard or something like
They have
that.
given,
Hmm?
they've submitted, but I think inadvertently, my manager didn't look their ages.
Where is that document?
That's it. Page number 38. Seizure
38.
list. Original birth certificate in the name of Anita Boro.
No, in your hotel, when somebody registers,
42 my lordship. One photo of Dipen Doimari. Aadhaar card, white Aadhaar number 5409. 827-88216. And photo of Anita Boro. Along with Aadhaar card number 5755-9373. 7732.
then so we will give him an interim protection then. If he has kept the record and then give it.
My lord, only, my lord, there is the, because the section POXO is at it. He is the only owner of the hotel, my lord. So
No,
whether,
he's
my
the
lord,
owner,
that-
he's not the accused.
He is not the accused, my lord. He is not the accused,
At best, he's the person who gave shelter.
my lord.
But is there any rule anywhere that minors should not be given entry in the hotel?
That is not there, my lord.
Then give an interim protection then.
My lord.
But this says counter and counsel for the petitioner. But I think in these cases, before giving any bill, I have to give notice.
My lord, that I am submitting, my lord. Because my lord, POXO section is there.
POXO is there.
Because of that only.
Okay. Third, Mr. S. Counter and counsel for the petitioner. Application number 482, page 1, Simla Police Station case number so and so under POXO Act. Notice to respond number 2 to be retrieved through the Office of the Office of the Public Prosecutor, sir, or no service on the respondent number 2 through the Simlaguri Police Station. Notice is made at number 1. 16/7/2025. Objection may be filed by them. In the meanwhile, the land APP shall obtain this scanned copy of the case diary, relevant pages of the case diary, along with scanned copy of the statement of victim to be produced in a seal cover. Distance and so.
It's a pending disposal of this application. May better be placed to grant ad interim bail.
We can't give now after this judgments of the Supreme Court.
16-7.
Hmm?
16-7.
16/7.
Yes.
Item 10.
May I please, your lordship, here in the petitioner is seeking
Where's the-
transit
where's the
anticipated
FIR?
bail, lordship. Your lordship may kindly see the notice entered to page 14, your lordship. The notice under section 35(3) of BNSS. Reference CN Police Station CR number 92/2025 under section 66D of IT Act, read with section 318(4), 319 of 2 of BNSS. All are non-billable section, your lordship. Then your lordship, can you see second para, hence you are directed to appear before the undersigned investigating officer at CN Police Station, so and so, within 7 days from receiving the notice. Now, your lordship, I have received the notice on 16/6/2025. 7 days already gone on today, is completed on today, your lordship. Next, the next page, page 15. What happens if I fail, your lordship? Last paragraph, failure to attend, comply with the terms of this notice can render you liable for arrest under section 35, 5 and 6 of the BNSS. So your lordship, I am praying for transit and anticipatory bail so as to facilitate me to obtain a regular anticipatory bail within the court of territorial jurisdiction, your lordship. Your lordship, in this regard, rely upon the subsequent judgment via Indira, your lordship. On when can anticipatory bail can be granted, your lordship? The lordship may kindly see the head note A, B, C last part. Then para 97, 98, 102 to 106.
Para?
Para 97, 98, 102 to 106, your lordship. Even in page 7 of the.
Be slow, I am not that fast.
Sorry.
97, 98, then
97, para 97.
97, 98, thereafter.
102 to 106, your lordship. Your lordship may also kindly see the head notes. A, B, C last
Head
part.
note is something I am trained not to read.
Sorry, I'm sorry.
I am trained not to read head notes.
Sorry.
No, not, I'm not asking apology, but I'm telling you.
When can a transit anticipated bail can be granted? One, if there is a genuine apprehension to his personal liberty or arrest, your lordship. Specified in only for a limited period. I am
Just
saying
this Information Technology Act.
D, cheating by persuasion by computer sources, punishment is 3 years. 318, 4, 7 years, 319, 5 years. All related to cheating. That is only clearance way.
Lordship.
The transactions in your bank account is huge.
Yes, I am not on the merit, your lordship, what the
No, but
concept of.
ultimately, we have to examine that also.
Yes, yes, yes. The concept of granting transit anticipated bail is the apprehension of the degree of apprehension of arrest, your lordship. There is the
Yes.
law behind your lordship, so as to protect the personal liberty as mandated under Article 21 and 14 of the Constitution.
Correct.
There I will, it is only for a limited period so that I can seek anticipated bail application.
In traveling, nobody,
Yes.
we are not expecting any policeman to come to train or to flight and catch you.
No, no, whatever, your lordship, all these sections are available, and since the period given in the notice has already expired, the last clause of the notice says that you will be arrested, your lordship. So there is a genuine apprehension of arrest, your lordship.
No, you could have informed them that you need 7 days more time. That you did not do.
That I received on 16/6 that.
Whenever,
I
even if you
consider
received today morning, you could have given them a letter by email that you need some more time. You received it only today
That I
morning.
can do now, your lordship, if you're.
But this is not a case of transit bill also.
Is a case of transit bail, your lordship.
No,
It is a Bangalore case, your lordship.
correct.
Yes. And the
But in your
petitioner
bank
is a.
account, the transactions
petitioner
are
is a
huge.
Buxa, Assam, your lordship.
The
Two
transactions are
different
huge.
districts. It is extraterritorial jurisdiction, your lordship.
Your transactions are huge.
It is extraterritorial, your lordship. So I am paying your
You can't
lordship.
give premium
Let
to
it
your
be for
fraud.
a limited period, your
We
lordship.
can't
so
give
that-
premium to your fraud.
Yes, I am not on merit, your lordship. I am just on the degree of apprehension of arrest. And this is the concept behind granting of transit anticipatory bail, your lordship. It has been very much laid down in the honorable in this Priya in the your lordship judgment. Your lordship may also
sorry, we
kindly
are not
see page
impressed.
7 of the judgment.
So,
Page-
Majindra, I am not impressed.
Page 7, your lordship.
You make a request to the police if you want more time, but it's not a case of remand for anticipatory bail. It gives a different meaning to It gives a premium to your to the entries of cash in your bank account.
No, I am not seeking any premium, your lordship. I am seeking for a limited period that will be considered by the jurisdictional court while I move anticipated bail application, your lordship. It is only for a temporary period, very much temporary period, your lordship.
No.
Your lordship may grant me 15 days, your lordship.
We are not inclined.
Within that, I will move
Make a request to the police. They will consider your prayer for additional time to appear.
That can be done, your lordship, that can be done, your lordship. But why I am apprehending, your lordship, the notice period says within 7 days, otherwise I will be arrested. That's why I have the genuine apprehension, your lordship. If your lordship make an objection to the effect, that will also suffice, your lordship.
We'll give that liberty.
Yes.
Heard Mr. R. Mazumdar and counsel for the petitioner, as well as Mr. K. Boshal and ABB for the state. Next para. Apprehending arrest in connection with CEN page 1, CEN police station, CR number 92/2025 under section 66 capital D of the Information Technology Act and section 318 within bracket 4 319/2 of the BNS, 2023. Petitioner has moved this application of DRS bail under section 482 of BNSS, pre-arrest bail. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner has received a notice under section 35 within bracket 3 of the BNSS, 2023, dated 23/5/2025, granting only 7 days time to appear before the cybercrime police station at Bangalore. Sorry, to submitted that they said notice was received on 26/5/2025.
No, your lordship, 16/6.
16/6. Okay, 16/6/2025. And by then, 7 days time is already expired. And therefore, apprehension is expressed for his arrest in connection with the aforementioned case. Next paragraph. Without entering into the merit of the matter, taking note of the grievance expressed by the learned counsel for the petitioner, this court in exercise of inherent jurisdiction under 482 is how much now?
482?
Is what provision now?
It is 482. No. 438.
482 becomes now
482, 528.
528. Inherent jurisdiction both under 528. So 528, the CRPC, court is inclined to
BNSS.
BNSS, inclined to grant 3 days time to the petitioner to request the investigating officer of That's on page 14.
EN.
CNP Police Station,
Bangalore district.
crime number
Bangalore.
CR number 92 of 1025 under section so and so. Seeking extension of reasonable time of 7 to 10 days to appear before the investigating officer. Full stop. In the event such a prayer is rejected or not responded to, liberty is granted to the petitioner to approach the court again. Much. Full stop. The request for extension of sign will be accompanied with a scanned copy of the certified copy of the order of this order passed today. Okay.
Obliged, Your Lordship.
We are giving you liberty to.
Yes, yes, that I think consider Your Lordship.
We are invoking not under this, but 428 we are invoking. Give it back. Close. Or rather, what we'll do is that we keep it pending instead of disposing it off.
It doesn't become nothing will come out. Obliged, Your Lordship.
Okay, list. Pending.
Or it can be kept pending. I will.
No, we're keeping it pending. Otherwise, you'll have to file again.
Yes, yes, I will file the email
This
request to Your Lordship.
list on 15/7/2025. Awaiting further developments. The pendency of this application shall not be a bar for the investigating or concerned investigating officer to respond to the request of time, request for time by the petitioner. Okay.
11.
Yes.
Lordship, Lordship, may kindly allow to withdraw this instant petition, Lordship.
You want to withdraw it? Okay. Your name?
D. Mehdi, Lordship.
Mr. D. Mehdi and counsel with the petitioner. Gives leave of the court to withdraw this application.
With a liberty, Lordship.
Liberty to approach again. Stop. Prayer is allowed. Matter since dismissed on withdrawal with liberty as prayed for. Mr. K. Bushel and APP is present.
Obliged.
12. Mr. Datta.
Hello. Your Lordship. But it's a POXO case, my lord. I think notice has to go first, my lord. Respondent number 2, my lord.
Same POXO. Mr. N. Datta, NJ Datta and counsel for the petitioner. Jurisdictional police station is Fakirganj PS case number. Fakirganj PS, the case number is Fakirganj PS case number 16 of 2025, page 1. Okay. It's not a charge sheet cases.
No, man, it's
Okay, scanned copy of the case diary along with scanned copy of the statement of the medical report and statement of the victim to be produced in seal cover. Scan copy, huh? Okay. List on. This is from Fakirganj. It takes some time.
16 or 17? To prevail. 16.
When?
18th, my lord. 18th, my lord.
Okay, 18. 7/25.
I'm obliged.
Seen you after a long time, Mr. Datta.
The lordship was busy, my lord, APSC case. We are following on that YouTube, my lord. I was following your lordship, my lord, in YouTube.
Following?
Following, my
That's
lord.
dangerous.
Because some other outstation council also came, my lord. For the state, my lord, outstation council also came.
But the hearing was very good.
Yes.
Very enlightening argument.
13.
But
May I please, my lord? My lord, petitioner arrested, my lord, illegal and unconstitutional, my lord. This violation of provision, my lord, 22 subsection 1, my lord. This additional affidavit, page number, my lord, 86, my lord.
It is a case, my lord. The IO had, my lord, recovered 33 kg ganja, my lord, from my lord, my lord, one vehicle, my lord. Petitioner, my lord, phone arrest, my lord. This is a 81, my lord. This additional affidavit, page number 81. My lord.
Page number?
81, my lord, additional affidavit.
Yes.
Yes, my lord. That, my lord, this order, the trial court, my lord, order dated 6/12/2023, my lord. May I read, my lord? Case record is put up, my lord, in petition file. Officer insert Sipazar PS IOS case the Sipazar PS submitting the accused Gunaram Doimeri. This present petitioner, my lord, name is Gunaram Doimeri, had been arrested in connection with Malba PS case number so and so under section so and so NDPS access. Another case, my lord. Udalguri district and forwarding.
Where you're reading where?
This first paragraph, my lord, page 81, my lord. This additional affidavit, my lord, page 81.
You see this? Is that page 81?
Additional affidavit. My lord, I'm very sorry, 89 page, my lord, not 81.
Yes.
Yes, may I read, my lord? The same petition filed by officer insert Sipazar PS Ioda case Sipazar PS submitting the accused Gunaram Doimeri, my lord, this present petitioner Gunaram Doimeri had been arrested in connection with Masbat PS case number so and so under section so into NDPS Act Udalguri district. Forward him to judicial custody 8/9/2023. It is submitted that the accused is also involved in connection with the Sipazar PS. Now this present petitioner is involved in, my lord, the Sipazar PS case number so and so, my lord. Pray for the sworn arrest of the accused order recorded his statement, my lord. Peruse the record of the learned public prosecutor Dorong so and so proper investigation cases where IO had sworn arrest the accused. This present petitioner, my lord, the Gunaram Doimeri is allowed in connection with instant case Sipazar PS case number so and so. That, my lord, what should you say aware, my lord? This Vihan Kumar, this, my lord, this violation of 22 Article 22 Section 1 and as well as, my lord, the 47 BNSS and, my lord, 50, the CRPC, my lord. No, my lord, in form of the ground of arrest, my lord, this present petitioner, my lord. And now, my lord, there are 4 numbers of accused persons, all 3 accused persons released on bail. I have annexed my bail petition, my lord. Onwards, my lord. My lord, page 54. This other accused persons, my lord, the release on bail, my lord, page 54. and page 56, my lord. Here in the case, my lord, this present petitioner involved, my lord, one witness, my lord, not co-accused, my lord, one witness statements, my lord. This statement, my lord, here. This bail petition, page 52, my lord. Petition name, my lord. One person name, my lord, Ratul Borua. On basis of the Ratul Borua statements, my lord, this present accused person was arrested, my lord. Neither conscious possession recovered from the present petitioner, my lord. No conscious possession recovered, my lord, this present petitioner, my lord. This IO recovered from this vehicle, my lord. This statement, my lord, page 52, my lord.
Yes, please continue. Please continue.
Yes, my lord. Page 52, my lord. Statement of Ratul Borua, my lord. My name, next statement Ratul so and so, age so and so, father name so and so, residence of so and so, so and so. My name in
What is the quantity seized here?
33 kg, my lord. 33 kg. Yes, ganja, my lord. He is, my lord, this Ratul Borua statements, my lord. That's present petitioner, my lord. This involvement, my lord, vehicles, the soul, my lord. They after 3 months, may I read, my lord, this page 52. I purchased the above vehicle so and so from Sanjeev Dev. This present Ratul Borua purchased, my lord, one Sanjeev Dev, but I have not transferred in my name, my lord. This Ratul Borua stated that. And now, my lord, after 3-4 months, I sold the vehicle Gunaram Doimari. This now present petitioner, my lord, name, my lord, Gunaram Doimari. After 3 months, they sold the vehicle, the Gunaram Doimari. This statement recorded, my lord, this IO, my lord, 5/12/2023. 5/12/2023. Kindly see. Page 49. That Sanjeev Day statement, my lord. That vehicle purchased, my lord, Ratul Borua. The Sanjeev Day. Page 49, my lord. That Sanjeev Day statement, my lord, page 49. My name and address is correct, so and so, so and so. I was purchased in auction in my name. Sanjeev Day stated, my lord. On 5/10/2022.
You want me to appreciate the evidence now?
No, my lord.
Then
there's nothing, my lord.
That's why we are asking you. You want us to, you want this court in bail application to assess the evidence now?
No, my lord. At this stage, only for
bail.
Yes, my lord. It's a trial, maybe. Otherwise, co-accused, my lord. Release on bail, my lord, and no conscious possessions recovered, my lord. And now, my lord, this petition is suffering from, my lord. Earlier, my lord, trial court, my lord, on medical ground, my lord, it's an interim bail, my lord. This.
When police arrests, everybody becomes ill. So don't worry. Everybody is ill. Yes.
Lordship. Here in
You have
this case,
you have consulted with the IO about this ground of arrest.
Lordship. Lordship, here is the in this case, Lordship, he was arrested on the basis of the warrant, Lordship. So, Lordship, when Lordship warrant itself is there, Lordship. So, Lordship, ground of arrest may not be required, Lordship. So, Lordship, one more thing, Lordship, I would like to point out, Lordship, that Article 22 and the entire issue comes from Article 22(1). And in Article 22(1), Lordship, may I read that one line, Lordship? What is there? It is from the behind command. Protection 22, Article 22, protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of this choice. So, in the mandates of the article says, Lordship, he has to be informed, Lordship. And Lordship, there is no way, Lordship, since Lordship I can show, Lordship, that since 1950, Lordship, this issue has been come and this has been interpreted, Lordship. that lordship, he has to be informed. It doesn't mean lordship, he has to be given the written ground of arrest, lordship. So lordship, in that case, lordship, this issue came lordship, reopened in lordship, in Pankaj Bansal case, lordship, in 2019, in 2023, lordship, 3/10/2023, lordship. Wherein in that case, lordship, it has been opined, lordship, that lordship, his ground of arrest has to be in writing. And that judgment is a prospective, lordship. Because lordship, in that, after that, lordship, R.K. Arora judgment came, and it has also stated, lordship, that prior to that, prior to the Pankaj Bansal, lordship, if there is no any ground of arrest, that is not the faulted with lordship.
That
So-
contention we have already rejected earlier in one of my orders.
Lordship.
That contention we have already rejected.
But lordship, today I am with one or two more judgments, lordship, which says, lordship, in A.K. Gopalan case, lordship, the famous case, lordship, A.K. Gopalan case 1950, lordship, wherein, lordship, in para 350, lordship, in this case, lordship, wherein it is the 6 judges bench, lordship, order judgment, lordship, wherein it is stated, lordship, may I read that para, lordship, 350.
Yes, you will have to give me a copy because I don't have
I
that
have given that booklet,
list of
lordship.
books. Just open it here.
It's a long, 150 pages. Para 350.
In this Vihan Kumar, is there any distinction made between arrest under warrant and arrest without warrant?
In Bihan Kumar, not lordship, but in Kasiri, this is a subsequent judgment, lordship, came, lordship, Kasiri, lordship. In that judgment, lordship, it has been mentioned, lordship, that when the warrant, warrant is there, that judgment also may read, lordship.
Kasiri.
Kasiri, lordship. This is the subsequent when to Bihan Kumar, lordship. Para 36. Diana, Para 36.
We opened this one.
Lordship.
A.K. Gopalan, paragraph.
A.K. Gopalan, lordship, para 350, lordship. এইটো আপনি এয়ার ওলাইছে নেকি এসএসসি ওলাইছে না এসএসসি 350 lordship. Clause 1 and 2 of the article 22 lay down the procedure that has to be followed when a man is arrested. They ensures 4 things. It is, lordship. First, right to be informed regarding ground of arrest. Second, right to consult and to be defended by a legal practitioner of his choice. Third, right to be produced before the magistrate within 24 hours. Fourth, freedom from detention beyond the said period except by order of the magistrate. So, lordship, here in this case, lordship, in 1950, since 1950, it has been opined, lordship, that, lordship, he has to be informed. There will no hand mention that he has to be informed by way of written ground of arrest, lordship. But after that, lordship, in lordship, I have submitted one more judgment, lordship, that is, lordship, State of Maharashtra versus Shobharam. This is, lordship, 5 judges bench, lordship. AIR 1966, SC 1910. Para 20, lordship.
Yes.
May I read, lordship? para 20. Article 22(1) is in two parts and it gives to persons arrested twofold protections. The first is that an arrested person shall not be detained in custody without being told the ground of such an arrest, and the other is that he shall be entitled to consult and to be defended by a legal practitioner of his choice. So, Lordship, here it is, Lordship, again mentioned, Lordship, without being told the ground of such arrest, Lordship. Article 22(2), after Article 22(2) comes, Lordship. So, Lordship, we can skip to this, Lordship, thereafter. Para 22, we can come, Lordship. Para 22, I consider that there is room for further deliberation on the point. I do not see how we can differentiate between arrest of different kinds. Arrest is arrest, wherever the regions. Insofar as the first part of Article 22(1) is concerned, it enacts a very simple safeguard for persons arrested. It merely says that an arrested person must be told the ground of his arrest. In other words, a person's personal liberty cannot be curtailed by arrest without informing him as soon as possible why he is arrested. Where the arrest is by warrant, the warrant itself must tell him. Where it is by an order, the order must tell him and where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all the first part of Article 22(1) lays down. I find nothing in Article 22(1) to limit the requirement of arrest by any particular kind. A warrant of the court and an order of any authority must show the reason for such arrest. Where there is no such warrant or order, the person making the arrest must inform the person the reason of such arrest. In other words, Article 22(1) means that it says in first part. Thereafter, again, Lordship, para 24. The same thing, Lordship, it has been reiterating that, Lordship, the person has to be informed, has to be told, Lordship. So there is nowhere mention, Lordship, that this is that Lordship, there has to be a written ground of arrest, Lordship. Thereafter, Lordship, in Kasireddy, Lordship, Kasireddy versus Lordship, Lordship may kindly come to para 36, Lordship. 28, sorry, Lordship, para 28 in Kasireddy, Lordship. So these two are the earlier two others, are the 5 judgments and 6 judgments, so orders, judgment, Lordship. So this is 2 judges, Lordship. In Kasireddy, Lordship, this is subsequent to the Bihan Kumar, Lordship. It has been, judgment was delivered on May 23, 25. So in para 28, Lordship, for purpose of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offence. However, the information should be sufficient to enable.
Paragraph?
Lordship.
Paragraph?
Para 28. Kasireddy Upendra Reddy. Para 28. For purpose of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offence. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The ground to be communicated to the arrested person should be somewhat similar to the search framed by the court for the trial of a case. The answer is para 36.
In this page 22, there is nothing. Page 22 of the this bail application, that is the order by which he is arrested. Nobody can understand why he is arrested. Page 22 of the writ petition.
That's one.
Yes, I am.
This is the order, Lordship, issue custody warrant against accused Gunaram Dharmai, Lordship. So against this, Lordship, warrant has to be issued. Warrant there must be one warrant, Lordship, because issue warrant is there, Lordship. Normally there is a issue. This is the warrant order, Lordship. Thereafter, Lordship, warrant will be there, Lordship. Sorry, warrant. So may I continue? He will see the warrant, Lordship, it found, Lordship. So Lordship, in para 36 again, Lordship.
So you see that warrant, if it contains, then your argument will be okay, otherwise. There are two more matters in the list. We may not have time to take it up. We'll list the matter tomorrow or day after. Day after. Day after tomorrow. Two matters are left out. Two matters, according to me, 16 and 17, two are left out.
So, 50 mile or exactly same, which also files bill application regarding violation of Article 22.
Whatever will be, but we'll have to,
Yes, ma'am,
we'll not have time today.
Yes.
16 and 17, due to positive time, these matters could not be taken up today. List on 16.
By Senate?
26, 2023.
Yes.
And what?
66.
1966. 1910. Yeah. 1910. 10. One. There in the course, but because Lordship sending the record, Lordship, some part it is resume Xerox, Lordship, it has been done scan copy. So
Okay, then call for the scan copy of the
and-
warrant issued pursuant to this.
that may be because
May I please, my lord? My lord, another ground, my lord.
No,
This
we'll call for this document first. Both sides are represented. Mr. K. Gogoi.
I'm PS Law.
PS Lagar, I'm sorry. Mr.
PS Law.
PS Lagar, ABP. Come upon perusing the scan copy of the records received from the learned tribunal, has submitted that said record does not contain the scan copy of the custody warrant issued pursuant to order dated 6/12/2023 by the learned special judge Darang Mangalday, asked in Sipazar PS case number 101 of 2023. Accordingly, the court is inclined to call for the scan copy of the custody warrant, if any, issued by the learned special judge Darang Mangalday in respect of accused Gunaram 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 Daimari DAI pursuant to order dated 6/12/2023, passed in Sipazar PS case number 101 of 2023. Next paragraph. The requisition shall be sent by email to the learned special judge, Dorong Mongolday, Okay. Taking note of the fact that the court would be on vacation. The last working day before vacation would be 27/6/2025. She is requested to expedite the requisition. Next paragraph list on. Take it after 26/6/2025. Next paragraph, let the order be brought to the notice of AUG Criminal Appeal Section. We'll see it day after tomorrow. Let us see if we can get it by then. And please give the list of books you have given, already given, the list of books. I'm sorry, Mr. Locker, I forget names.
Pranjit Singhal, PS Locker, Pranjit Singhal Locker.
No, that's why I was saying, I'm sorry that I forget names.
I am appearing after a long time in this court, that is always.
Names is something I always forget. I may not forget the provision of law, but names, I don't know, I just can't remember. I'm sorry. No, I should not forget your names because your assistance in the courtroom, so far as when I am there in the bail matters, is very excellent.